We are live. We are live. Welcome to college football's Peek Around the Corner, PATC breakfast. Holy smokes. Holy smokes. Welcome into college football's Peek Around the Corner with your host, Greg Flugar. We cover everything in college football because we love everything in college football. And if you do as well, please subscribe to our channel. Smash the like button if you like our content. Share the video with your family and your friends if you want to support this college football Rebel Outpost channel with a donation. Hit the $, make a comment, and I will get to you super chat as quick as I possibly can. Everybody, welcome on in. Come on in. Don't be afraid. Come on in. Come on into the studio that sits on the corner of Keith Jackson Parkway and Kurt Gowdy Avenue. Do not be afraid. Do not be afraid to be a legend in the chat room with the comments, with the phone calls later in the show. Matt Baker, the great Matt Baker, Tampa Bay Times. Good morning. Good morning from a bench outside room 3D of the Leon County Courthouse. It's Florida State versus the ACC coming up next. So we know that Matt Baker is in there. So we'll be keeping an eye on his tweets. I also believe CFB Playoff Edits has got his breakfast burritos ready to go. Big Ten fan, next dominoes in the saga happened today. Holy smokes. David M., all this is nice, but as yesterday's show was saying, most probably a settlement is going to happen between both parties. Well, look, I can tell you what the peek around the corner, the very latest, right? We believe that Florida State, Clemson, North Carolina, and probably a couple other schools in the ACC will not be a member of the ACC after the next 3 years. Sometime within the next 3 years, they're gone. Where they're going to end up, where Florida State, Clemson, and North Carolina are going to end up, we've been told, hold on, you move too fast. You got to make the story last, just kicking down the cobblestone, looking for fun and feeling groovy. We don't know. A lot of people say they know. We've decided to take down the odds in the sports book because we've been told, not so fast. There's still a lot to be determined. The settlement number, and then the first party talks. Now, what if a month ago they decided on a settlement and they've been talking amongst themselves? The ACC has given these teams the ability to have first party talks. I don't think that's happened. I don't believe that has happened. But that would be the ultimate cloak and dagger. But there will not be first party talks with the SEC or the Big Ten. The legal counsels of both conferences will not have it happen. Jim Phillips warned the Big Ten, warned the Big 12, warned the SEC. And they said, absolutely, we're not having first party talks with any of your universities. That definitely did happen, and it was recent. So we don't know. We just don't know. But this court pleadings today, more drama ahead of us. Buckle up. Brace for impact. We are looking for a live feed. We are looking for a live feed. Now, I've got WCTV live stream Tallahassee, Florida, all set up. So if it goes to the courthouse, we should be able to cover it. That is our first goal this morning. To give you a live stream, just like we've done before in Leon County. YouTube, this is fair use doctrine. We haven't been dinged by YouTube yet. Going into these courthouses, we don't believe it's going to happen. We think this is going to be okay. YouTube, fair use. Okay. All right. Again, we have the WCTV live stream. We are hoping that that live stream comes out of the courthouse. But if you see another live stream, DM it to me at my X account at Flug Umpire. You see it on the bottom of the screen. JD, Mr. Seminole, PATC Community, John D. JD has given me another account to keep an eye on here. I'm going to have to open up a whole bunch of different stuff here. Give me a moment. Give me a moment here. We're going to be following all no's. All no's. Thank you, JD. Appreciate it. All no's. Florida State ACC contract case, Tallahassee, at the courthouse. I don't have all day, but I'll follow while I can. I hope this isn't hours of jurisdiction arguments. I miss the more fun issues later. So we'll be following him as well. Again, we're looking for a live stream of the courthouse. That is our number one goal. Once we get that locked in, we can sit back, watch the proceedings happen. Minnesota Seminoles, thanks for coming on in. Prof. Caleb Ramirez, Florida man. Monavision is listening in. Mr. Buckeye Thomas is in the house. Go Cyclones. Matt Neeson. Matt Neeson is the only person, besides John Kurtz, besides John Grove, besides a handful of Kansas State fans, Matt Neeson is the only person that is happy with my Big 12 predictions on yesterday's show. Man, I have been getting crunched by everybody. The Oklahoma State Cowboy BR 7062. Hey y'all, Greg the Cooler. Monavision. Also, no future Big Ten expansion without checking that Notre Dame's feelings do not get hurt. Preston from Greensboro. What do you think of Josh Pate's ACC tweet yesterday? We spent a lot of time on that on our live show yesterday. We'll hit that later on today. I gave you my thoughts on it. People gave their thoughts on it. We'll hit it again later today, Preston, Greensboro. Friends call me Sean, John, Drive, Florida Man, Expedition, Greg. They're all in the house. Greg saying fair use like Michael Scott declared bankruptcy. I declare bankruptcy. I declare fair use. YouTube. Put that in your algorithm. Put that in your algorithm. Joe Z, good morning. Jay Chapman, good morning. Greg, the architect is here. PA No Fan is here. Michael Morse is here. Rock and Rant, I love the smell of realignment in the morning. Nothing else in the world smells like that, Brett Taylor. I'm assuming this hearing is no more than motions and oral arguments. Will the judge make any decisions today? I'm sorry, Brett, I don't have the answer. I don't even have the questions. Somebody in the chat room, some people, let us know what you're thinking. What is Judge Cooper going to do today? What is he going to, is he going to make any decisions? Is he going to make any rulings? Caleb Ramirez, as far as I know, we've had a live stream for every pleadings since this has begun. Lee's in the house. Dark Moon is in the house again. We're looking for something here. We are looking for a live stream. If you get one, if you have one, send it my way. Please send it my way. Now I'm going to open up, I believe, hold on here. Chris Nee of 247 Sports. He's also in the courtroom, and I will be relaying to you all what he is saying. Both legal teams are present and accounted for as we await to enter the 3D and appear before Judge Cooper. Room 3D in the Leon County courtroom. Again, we're waiting for a live stream. If anybody gets their hands on a live stream from the courthouse, let me know. Thank you, Michael Monk. To keep the lights on, thank you so much for your generosity. Thank you so very much, Michael Monk. Justin Lucas, this hearing is not on the merits of the case. Go Black 45, nothing will really happen today. He will keep pushing mediation. They've already set up mediation, though. They've already set that up. They've already selected a mediator, as far as I know. Okay, I'm going to have to look for another WCTV right now is not showing anything. So I'm going to go to the WTXL. I'm going to try that next. Again, if you see a live stream, send it my way. We are working on providing a live stream in the courthouse of Leon County. Judge Cooper. I do not believe anything has begun yet in the courtroom. The people who are positioned outside the courtroom, I do not think they have entered. I don't believe they have entered into the courtroom. Justin Lucas, I would expect Judge Cooper to deny the ACC's motion to dismiss. And then the ACC will try to appeal. Again, we are hoping that a live stream begins in the courtroom. WCTV, we're looking at that. We're looking at WTXL. But the main one is WCTV. Again, if you see a live stream pop up, let me know. Send it to me. Chris Nee is reporting. You'll be shocked, but this is going to start later than the scheduled 9 a.m. in Tallahassee. It's 9:08 in Tallahassee. Chris Nee, 10 seconds ago. I don't expect any water bouncing moments or big fish eating little fish moments out of today, by the way. Think things will simply progress forward with regards to defining jurisdiction. That's what Chris Nee believes. Again, Florida State, FSU 247. Matt Baker hasn't tweeted anything since 21 minutes ago when he was sitting on a bench outside of room 3D in Leon County. I don't believe Matt Baker is in the room. I don't believe Chris Nee is in the room. I don't think they have let people into the room yet. So that could be the reason why the live stream hasn't begun in the courtroom. So please hang with us. Proceedings have not begun. Mob Prof, I missed the Big 12 prediction show and I don't see it on the list of previous show. It was the show from yesterday, Monday, June 17th. Monday, June 17th, Mob Prof. Florida man, Judge Cooper is always late. Florida man, he's probably looking for his notes in case his laptop doesn't work. The last two times his computer did not work in front of him at the beginning. Try WTXL. I have. I don't see anything up there. If somebody sees WTXL is providing a live stream, send it my way. But I have tried that as well. I've got everything up, guys. I got everything up. Nothing's happening yet. There are people asking for a live stream link on 247, and right now none has been provided. Brett Taylor says the Tallahassee Democrat is reporting the hearing will start at 9:30. Thank you, Brett Taylor. Appreciate it. Good morning to you, Movie Time Blues. Okay, so let's set the stage here. More jurisdiction talk. Judge Cooper probably going to deny the motion to dismiss, the ACC's motion to dismiss it out of Tallahassee, dismiss it out of Leon County. The ACC believes it should happen in Mecklenburg County. This is all in the backdrop of Josh Pate. Josh Pate, we covered it yesterday. He put up an interesting post. I'll put that up once again. Here it is. We talked about it yesterday. What does this mean? Josh Pate, ACC. The glass, Jurassic Park, T-Rex is getting close, or T-Rex broke out of its cage. Somebody said, does this mean the ACC is going to expand? And Josh Pate, the league is about to do the opposite of that. What did Josh Pate, what information came across Josh Pate's desk? What does he believe to know? Is there a leak? Is there a settlement and it's been leaked? And the information is embargoed? Does Josh Pate believe a settlement is at hand? Does Josh Pate believe that North Carolina is about to get the Board of Governors to give the Board of Governors is okay with suing, initiate litigation in the state of North Carolina? Or could it be the dissolution theory coming up out of the grave? There's only about 12 days left before SMU becomes a member of the ACC, where it becomes more difficult to find over 50% of the schools in the conference to vote to dissolve the conference. I'm not a believer in the dissolution theory, but for those who are, there's about 12 days left, really, for that to happen. The odds drop even more if it doesn't happen in the next 12 days. What is Josh Pate alluding to? We asked the question yesterday. For those who were not able to watch the show yesterday, who've come on in the morning today, what is this all about for Josh Pate? The league is about to do the opposite of that. The opposite of expansion is contraction. And the key word Josh Pate uses is about. The league is about to do the opposite. Maybe what Josh Pate has heard is incorrect. Maybe he just received partial information. Maybe he jumped too early. Or maybe he's absolutely nailed it. We at Peek Around the Corner, we reported to you about 5 or 6 weeks ago that we were told that Florida State was willing to pay a premium price to get out early, to get out before the August 15th. They've got it all lined up. Remember in the Holy Smokes Theater, a man with a beautiful suit laid a suitcase on the front of the stage, put the key on the suitcase. The Florida State at the center of the stage picked up the suitcase. We believe Florida State's got the money and they're ready to pull the trigger, but they need the partner, ACC, to accept it. Is something about to happen? Is something about to break? And we also reported to you here at Peek Around the Corner that nothing has been determined. We had to take the odds down from on any given Saturday sportsbook. On the corner of, not on the corner, it's about 2 miles south of Keith Jackson Parkway and Kurt Gowdy Avenue, 2 miles south on Kurt Gowdy Avenue sits on any given Saturday sportsbook. We had to rip the odds down. There is too much still unknown. We were told that. Pull back, Greg. Pull back. There is too much going on. Or we should say maybe not enough going on. Lee believes Josh Pate is at the Elite 11, the camp for the quarterbacks. I'm sure he has heard something significant. Stephen Vitt believes not so fast. Josh Pate has been given bad information, in his opinion. Casey Morelli, when does Florida State announce they're going to the Big Ten, Greg? While we believe that the Big Ten, Florida State is a slight lean to the Big Ten, we don't even have that up in our sportsbook odds anymore. Of course, look, we believe Florida State's going to leave the ACC within the next 3 years. Probably sooner than that. But within the next 3 years. This year, next year, the year after. They're going to the SEC. They're going to the Big Ten. Or I suppose there's a very small chance of the Big 12. They're leaving the ACC. Could Florida State be in the Big Ten by 2026? By 2025? Yeah. But it is not for certain. It is definitely not for certain. This is what we were told a few days ago, late last week. So nothing has been determined. There has not been the first party talks. The Big Ten, if they could have their choice, they would wait a year to see how their TV schedule works, to see how Peacocks works, the streaming deal. They believe the Big Ten is getting a little bit more optimistic about a streaming future. In other words, if the Big Ten in their next expansion will probably include another media partner, a streaming media partner, very well could be Amazon. And if that's the case, then Amazon will be part of the decision making on the next expansion. Then you've got the issue of new presidents coming in, leaving, coming on in a lot of the Big Ten universities. And then we've got the information that the Big Ten wants to see the interest of the largest dominoes. If Clemson and Florida State find a settlement agreement, it starts at the biggest dominoes, which is Notre Dame and North Carolina. Nothing has been determined. There is no offers on the table. Could Florida State end up in the Big Ten? Absolutely yes. But we've been told that that is not a far gone conclusion. The serious talks have not happened. That's the way it is. D5 Terps, the Big Ten will absolutely be adding partners in the next round. Apple or Amazon. Expedition Greg, North Carolina will end up in the SEC. You have to call it Jimmy the Greek Theater, Greg. Makes too much sense. For us old guys, yes, Jimmy the Greek. I think for all the new people, just like when I say Kurt Gowdy Avenue, some of them have asked me, who's Kurt Gowdy? And I'm like, woo! Go Black 45. Would be something if the lawyers tell the judge we've reached an agreement. I think it would have happened before this morning. I don't think they would have had... They could have easily contacted the judge last night. Steven says Judge Cooper won't grant the ACC anything of real note. Preston from Greensboro, you're making me feel old. I think Netflix could be in play for the Big Ten. Coy. Okay, it's 8:23. Let me check on those people who we know are in the courthouse. Give me a moment. Matt Baker. Again, his last tweet was 35 minutes ago. He's sitting on a bench outside of room 3D of the Leon County Courthouse. Let's check with Florida State 247. Okay, we've got some good information here. Chris Nee, Florida State 247. WCTV is setting up to stream. WCTV is setting up to stream. We have moved to room 3G, where every other moment of this has happened today. It was scheduled today to go to 3D, but it looks like they're going into the room that they've been in with all the other proceedings, 3G. So, WCTV live stream, we're going to have it, ladies and gentlemen. So please stick with us, join us. They're setting it up. They are setting it up. When it starts, if somebody, because we're doing a show here, I just don't want to sit here and look at the WCTV. If somebody, once it hits, give me a heads up. Sean, looks like I'm not going to get much done at work this morning. Whoa, Nelly. The fullback out of Macon, Georgia. Whoa, Nelly. Rumbling, bumbling, stumbling. Keith Jackson. Go Black 45. I don't know why people think this will be quick without a deal being made. My prof says the Domers are up to something. Baby Wants Bling. Good morning. Thanks for coming on in. Baby Wants Bling. Clay Try. Let the rumblings begin. Tracy FSU is in the house. Steel Austin is in the house. Holy smokes. Dave Miter. In other news, Kraft looking into private equity due to a recent drop in cheese sales. Peter Shields, Gold Knolls. Jay Chapman, is this or a Zoom meeting for me today? You all can see what I chose. Okay, we're still waiting. Should be getting close, ladies and gentlemen. All knows. Again, there was a technical delay. They're changing the courtrooms. So we've already had one delay. CJ, I'm here for the smoke. Doug, ACC and another one bites the dust. The time is nigh. Tracy FSU, Judge Cooper, computer never works. Yep. Chris Nee, we're still awaiting entry into the courtroom. Movie time blues. I'm stumped over what the biggest domino would be here. The biggest domino is North Carolina and Notre Dame. So we were told late last week, and we reported on Friday and on Saturday. While there's interest in Florida State, there's interest in Clemson, that the Big Ten would rush in to have those meetings with those schools, first party talks. They're going to wait to see the interest of Notre Dame and North Carolina if they're interested in making a settlement with the ACC, and see what they're interested is with the Big Ten. So, in other words, the Big Ten ain't going to rush in and make the first deal with the schools that are first available. This is what we were told. Go back 45. I see the SEC making a scheduled alliance with Notre Dame just to keep their schedule up. They will play 3 SEC teams in the next 6 years. More is coming. Brett Taylor, WCTV, stay tuned for a live event. Again, if you're just joining us, WCTV has set up in the courtroom in Leon County. Once it starts, we are going straight there. And then you can make comments during the live stream. When they take a break, we're going to open up the phone calls. Let us know in real time your thoughts, what you're thinking, as Judge Cooper presides over ACC versus Florida State in Leon County, still dealing with the question of jurisdiction. What venue should this go to? The ACC has filed a motion to dismiss. Most people believe Judge Cooper is going to deny that motion. What else is going to happen today? We're going to find out. Buckle up, brace for impact. Brace for impact. Again, Brett Taylor, hit that like button while you're waiting. I do appreciate that. It helps us with the algorithms of YouTube. And then go ahead and subscribe to our channel if you haven't done yet. If you haven't done it yet, subscribe and then have your notifications turned on. We go where the story goes in college football. That is what we do. And we can come on live at any time. Breakfast, We could go on live again later today, whatever it takes to give you the college football news and reports. We talk everything in college football. Thank you, Jay Go Blue. I do appreciate it. Again, we're waiting. We are waiting. We are waiting. We are waiting. Stand by for a live event. We are waiting. WCTV, we're going to give you the live stream. We are quickly checking in with 3 people we know that are in the courthouse. Stand by for live event. This is what we're seeing, ladies and gentlemen. This is what we're seeing. We're waiting for the live event from Leon County. Again, during the break, we will open up the phone lines. Please put down your comments in the chat room while we're watching. Mark Hudson, there are technical issues. They are switching courtrooms. They've gone from room 3D to room 3G. That is what we believe. Brett Taylor, thank you so much. They have muted the sound and quit playing music in the background. Should be real close to going live now. Thank you for the reminder. I just put our volume all the way up. We are standing by for a live event, Leon County. It's been delayed. Young Seminole, you have not missed anything. It's been delayed, technical issues. Supposedly, we're starting real soon here. Judge Cooper is on the mic. He is speaking about issues signing on to the computer. Once again, Judge Cooper is having a difficult time signing on to his computer. They are in the courtroom. They are in the courtroom. So we should be seeing something here. It's about to begin. The computer's not working. I do appreciate that, young Seminole. Did the ACC ESPN officials hack into Judge Cooper's computer? Do not know. Here we go. We've got something, ladies and gentlemen. We've got something. Hold on. We are live. We are live in Leon County. We are live in Leon County. WCTV. Fair use, fair use, fair use. Okay. I've got the volume up, ladies and gentlemen. There's nothing more I can do with the volume. I think it's their microphone they don't have on yet. I do remember this guy. Oh. If you've just joined us, the courtroom proceedings in Leon County has not begun yet. There was a technical issue. They had to move from room 3D to 3G in Leon County courtroom. So Judge Cooper is presiding. I think they're having some microphone issues. Hopefully this will begin soon. It was supposed to start 42 minutes ago. We are still waiting, still waiting. Tracy FSU, are you on WCTV? I'm just wondering how you could hear him talking.
Oh, that's that door that's hard. Hey,
Oh, I can hear that now too.
so I figured that's what you want me to do. So I've gotten through the Dell logo and now it's saying please wait. So I think it must be running updates or something.
Got it. Again, if you just join us, we are in Leon County courtroom. Judge Cooper presiding. There has been technical issues. It was supposed to have begun 46 minutes ago. We are still waiting. Matt Baker is reporting. Matt Baker is reporting. He's in the courtroom. Tampa Bay Times. The judge has informed us that he's restarting the computer. Perhaps the recent software update caused an issue. We're still waiting on Florida State v. ACC round 3 to start up. So please hang with us here at Peek Around the Corner. We're going to be live streaming the court proceedings in Leon County, Florida State versus the ACC. Grassy from Winnipeg, Manitoba. Greg, keep rowing the boat. Absolutely, Grassy. Thank you so much. Thank you for joining us. Keep rowing that boat. Everybody row in the same direction. When the oar hits the water, that is your energy. Everybody is going in the same direction. Follow the compass. Follow the Great North Star. Minnesota Golden Gophers. Tracy FSU says it is starting. Starting now. I think you guys are ahead of me, but that's fine.
Working with Adobe Acrobat AI Assistant, I'm creating a business of
Okay, I got it. Give me a moment here. Give me a moment. Give me a moment. We finally got it. Come on, come on.
Okay, 144, 503, 97. All right. So without objection from FSU, I'm going to admit this if you want to label it as an exhibit, or you can file it, whichever you prefer, but I'll consider it.
Thank you, Your Honor.
With that, I agree. I don't see any need for any further testimony. I've read everything that's been provided to me. I reread the Second Amendment complaint. I read defense's motion a couple times. I reread some documents from the first hearing and looked at some notes of mine that I have on various other cases on personal jurisdiction, and have looked at the affidavits provided, primarily the affidavit from ACC. I have, if I can't find it, I can print it off my computer, but I made myself a little summary of what I thought pertinent points made in the ACC's affidavit as to this case. There's a section at the end, a big chunk at the end, dealing with the confidentiality of the ESPN agreement, and I don't know that at this point for this motion that's particularly relevant, but I understand why you're putting that in. So, that's the ACC presented one affidavit for Mr. Terrio.
That's correct, Your Honor.
And FSU presented an affidavit for Mr. Londot. And also, I think, is it two other affidavits?
There are, Your Honor.
Okay.
Gander
Mm-hmm.
and Cindy Hartman.
One was from the person who's in charge with the sports marketing, the video.
Right.
Okay, I would have to look at it for the other affidavit to jog my memory, but I did look.
She's in the sport. She's an associate athletic director. So she testified about the number of games.
Yes. Yes. Okay. That brings it back. So, I'm going to make some suggested time limits, recognizing that, like all plans, once the battle is started, all the plans go out the window. But what I was going to suggest, so that we're not here just for too long, is take an hour for the jurisdiction motion total. That's 30 minutes aside. So defense would go first, it's their motion. Plaintiff would go second. Defense would have the reply and final argument. Defense gets a total of 30, plaintiff gets a 30. I'll do my best to keep time. I'm not that good on doing it, but I'll do my best on that. With this proviso, if there's a valid reason for more time, just ask me for it, and I'll provide it. And it may be I might have a question or something. I'm going to try to keep that limited also for time-saving purposes, because you all have written extensive comments on this motion. And then once that over, if there's a need to take up the remaining motions, I'm going to try to do that again in an
Jurisdiction.
hour. And we'll just see how that
ACC is up first.
goes. Some of those motions have been ruled on already. So we'll just see how that goes. And I don't want to set a time, because the first hurdle in this track meet, so to speak, is jurisdiction. And we have to get by that before we get to the other motions. So I'm ready to hear from
Thank you, Ron.
ACC. Is there anything ACC wants to bring up before you start? Thank you, Mr. Lawson. We might want for the court reporter to get appearances, but just since you already started with ACC, if you'll just tell us who all attorneys are here for ACC. Okay. All right, thanks. From the plaintiff?
David Ashburn, law firm of Greenberg Trauer, representing the Florida State University Board of Trustees. My partner, Pete Rush, is going to be arguing motions today. To my left, John Rondat, and we also have General Counsel for FSU, Carolyn Egan, and also in General Counsel's office, Meg Yard.
Egan and Meg
Yard. A-R-I-B.
Okay. Hold on a second. I had some notes from the last hearing, so I'll keep these by my side over here. I have a copy of, let me find the statute that I wanted. .193, I'm sure we're going to be talking about that, so I have that. Okay, I'm ready. Probably,
Speak in the mic,
probably, yes, the podium with the mic, just so your voice can be captured on the camera.
I thought you prefer me to face you rather than...
Either way is fine with me.
Okay. Your Honor, good morning, and thank you for the opportunity to argue our motion before you. Before you this morning is the ACC's motion to dismiss the Second Amendment complaint based on lack of personal jurisdiction. And as the court's aware, and as the first DCA has instructed us, personal jurisdiction comes in two flavors, general and specific. FSU has tried to assert general personal jurisdiction under both theories of jurisdiction, general and specific, neither of which succeed.
As I understand, general is that's the jurisdiction that applies if it's your home state.
Correct. The U.S. Supreme Court has told us that in order to qualify for general jurisdiction, you have to essentially be at home in the state. So, for example, that would be a situation where, hypothetical, a woman from Virginia slips and falls in the ACC's headquarters in Charlotte, and she chooses to sue the ACC here in Florida. for that injury. That would be general jurisdiction here in Florida.
Right. In most cases like this are generally specific.
That's correct, Your Honor. Specific jurisdiction is more limited. It's under one of the enumerated factors under Florida's long-arm statute. And of course, as is provided for and required by our long-arm statute, it is restricted and focused on any cause of action arising from the following acts, meaning the acts that are enumerated under the statute.
And I assume that we're following the let's see.
The ACC
track
is going to have 30 minutes to talk jurisdiction,
for the,
and then Florida
analysis
State will
framework
talk
set
30
forth
minutes
the
in regards to
Venetian salami
jurisdiction.
case.
Absolutely, Your Honor. And as the court is familiar and is well aware with Venetian salami, that's a two-part analysis. Whether you're going under general or specific, plaintiff has to establish that it falls within the scope of the statute, the long-arm statute. And then even if it does, they also have to establish that they've satisfied the due process requirements. And and as we discussed in our brief, and as the court's aware, the due process analyses for general and specific jurisdiction are different. We've already mentioned and talked about the fact that general jurisdiction, the defendant entity has to be essentially at home in the jurisdiction. For specific jurisdiction, it's I think sometimes more familiar concept of minimum contacts, and that's related to specific jurisdiction. And as the Florida and the federal courts have instructed us, general jurisdiction is a much higher threshold than specific jurisdiction. So as I mentioned, FSU hopes to establish personal jurisdiction under either theory, and I wanted to we have some limited time, so I wanted to just briefly touch on the general jurisdiction theories for the court.
All right, I wanted to look at a relatively recent U.S. Supreme Court case and get your take on it. I had a note on that, but I think I can find it on this document here. Give me a minute. Well, I will locate that, but it's a recent U.S. Supreme Court case that was written by Gorsuch. The name escapes me right now.
Is it the Mallory case, Your Honor?
Yes.
Yes.
Written by Gorsuch, and an interesting alignment of justices on that case.
Yeah.
And while it dealt with an issue that's different from this, that in that case there was a written agreement to be subject to jurisdiction in a state in order to be allowed to do business in that state, which is not the case here. But he did talk about going back to international shoe, and he talked at length about the test for determining personal jurisdiction, in particular under what I would call the Part 2 analysis of Venetian salami, the federal minimum contacts analysis. And my take on what he said was those rules are designed to broaden jurisdiction, not to restrict jurisdiction. I don't know if you agree or disagree with that. I will find you the quote later, but that's my recollection of what he said.
Okay, Your Honor, thank you. I'll appreciate the opportunity to discuss that, the Mallory case. And you're absolutely right. The context and the facts of that are different. They're as I recall, the corporation had registered to do business in the state, and I think one of the requirements of the statute when you register to do business is that you agree to submit to jurisdiction. And I think
that's why the significance of that case is that the test that's set forth in determining minimum contacts, it's really a fact-specific test for each case, and the policy as announced by the U.S. Supreme Court is that it's don't want to use the word liberal, that might offend somebody, but it's a liberal reading of jurisdiction, not a restrictive reading of jurisdiction. And we'll rely on what he said, and I have that marked up, and as soon as I find it in a break, I will read it to you.
Great. Thank you, Your Honor. And of course, the test is if we're kind of jumping ahead to the due process analysis, and if we're talking about minimum context, then we're in specific jurisdiction land.
Mm-hmm.
And that's the pretty familiar test of minimum context, and could a defendant reasonably anticipate being hailed into court for the specific acts that are alleged to have occurred,
Mm-hmm.
and that cause the basis of that form the basis for the cause of action. And that's a familiar test that Florida courts have applied consistently in our jurisprudence, and the court is right, it is fact specific. Whether it broadens or restricts jurisdiction will depend on the facts of the case and the nature of the claims presented to the court.
Mm-hmm.
So I think that's would be just my initial reaction to that. But if you give me the opportunity to discuss the issue that you,
Sure.
With Justice Gorsuch's, in his opinion, I'm happy to do that.
Okay.
I don't know if the court wants to discuss general jurisdiction. You're exactly right. That is harder to really reach.
I got the impression that FSU in its response is, FSU, tell me if I'm wrong, is not relying heavily on general jurisdiction, other than I think its argument is, since ACC is an association, that each member, that it's a resident or a citizen of the state of each member. And I don't know if that's a general, does FSU relying on general jurisdiction? Should we talk about that or not? I don't want to speak for you.
Yes, Your Honor, I think we should under 493, 198, 2. We are also relying on general jurisdiction.
Okay.
We do agree that we think the specific jurisdiction is simpler, more straightforward, and much easier.
Mm-hmm.
But we do think that they have minimum contacts here, and that, quite frankly, there is general jurisdiction, given 5 contracts that they've entered for substantial services.
Okay. Let me suggest this. The word hyperbole is not a word I use a lot, but I'm using more every time I read pleadings in this case from both sides. So save the hyperbole for me, both sides, and you just let's get to the point.
Sure, Your Honor. And so let me briefly address the general jurisdiction.
Get to the
then,
point,
because
Judge
they really
says.
rely on 2 arguments. And the first one is exactly what the court identified, this notion that because the ACC is an unincorporated voluntary association that's organized under North Carolina law, it is nonetheless a citizen of every state where one of its members is located. And as you notice, FSU doesn't cite any case law for that authority, and it seems to be derived from notions of federal diversity subject matter jurisdiction. Well, actually, let me back up. They do cite one case. They cite a case that's the Subic Bay Marine case, and the site is 257 Southern 3rd, 1139. That's a case out of the 5th DCA from 2018. That case doesn't really help FSU here because that case holds that, quote, because Florida residents are subject to the general jurisdiction of Florida courts, and under Florida law, corporations are residents of their state of incorporation, then corporations incorporated under Florida law are Florida residents subject to the general jurisdiction of Florida courts. And of course, as the court has already noted, the ACC is not a Florida corporation. So the Subic Bay case doesn't really get them anywhere on that point. And as I mentioned, they seem to be conflating concepts from federal subject matter jurisdiction that's based on diversity of citizenship with personal jurisdiction arising under Florida's long-arm statute. And as the court is aware, federal subject matter jurisdiction based on diversity is derived out of Article 3 of the U.S. Constitution, which extends to cases and controversies between citizens of different states. And then in 28 U.S.C. 1332, Congress addressed the issue of what is citizenship for purposes of diversity jurisdiction. And when it's talking about corporate, and the statute talks about individuals and corporations, and since it only talks about corporations, the federal courts had to decide, well, how do we treat entities that aren't corporations, LLCs and partnerships,
Could I ask you this question?
of course.
When I was a lawyer, I did a lot of litigation in federal court from both the plaintiff side and the defense side. Generally familiar with personal diversity jurisdiction. I always understood it to be perfect diversity. You had to be citizens of two different states. What do you understand the plaintiff's argument is on diversity jurisdiction? It's not perfect diversity, because if the claim is that ACC is a citizen of Florida, that can't be perfect diversity with FSU. Does the concept of diversity jurisdiction even apply in state court?
No, it doesn't, Your Honor. That's something that...
If someone wanted to remove it, it might. Maybe it's too late to do that, but
Correct.
or it might not be too late. But
Correct, Your Honor. Diversity jurisdiction does not apply in the state court in the way that FSU is attempting to import it into notions of personal jurisdiction. And as we've cited in our moving paper, there's at least 3. It's hard to find cases that deal with this because it's such an odd argument. But we found at least 3 cases and cited them in our brief, Your Honor, that expressly say the notions of federal diversity subject matter jurisdiction are different than the notions of personal jurisdiction.
correct.
And so to conflate them, which is the first kind of argument for general jurisdiction, that doesn't work. The courts have rejected the notion that you
And
can...
federal subject matter jurisdiction has to be based on a federal law or constitutional right.
Correct, or diversity.
Or diversity, but non-diversity would be like a Section 1983 claim, various types of civil rights or employment claims under federal statutes. Diversity can be any tort case, conceivably a contract case. It just has to be perfect diversity. You're in Georgia, I'm in Florida. Perfect diversity.
That's correct, Your Honor. And if we were in that situation and talking about subject matter jurisdiction, we could talk about whether there's diversity and if there's, if we're in state court, if we could remove. Those issues aren't before the court.
Correct.
We're talking about personal jurisdiction, not subject matter jurisdiction. And as I said, we've cited 3 cases in our brief that expressly hold that you can't conflate those 2 concepts. I mean, that's really what seems to be the attempt. The other attempt to allege general jurisdiction, and when you go through the allegations that FSU claims establish general jurisdiction, it really just summarizes or re-encapsulates the allegations that it's asserting to establish the various parts of specific jurisdiction, and then kind of says, well, take it all together. If we kind of throw them all together, that's enough for general jurisdiction. Again, no case cite for that somehow you can aggregate different pieces of specific jurisdiction to create general jurisdiction. And that would be contrary to the requirements for general jurisdiction that the ACC's activities in Florida be so extensive and pervasive that a significant portion of its business operations or revenue are derived from established commercial relationships in the state. So, their argument is...
Well, nobody's provided me that data, have they?
Correct, Your Honor.
Although FSU and Miami, well, maybe FSU and Clemson, probably the 2 biggest revenue generators in the conference, but that's not of the record.
That's not on the record, Your Honor. And the notion that the sum is greater than the parts, that there's no case law for that support in order to create general jurisdiction.
Okay.
Even if the court felt that they had complied or met the requirements of the long-arm statute onto that, they still have to get over that due process requirement, which is the due process requirement for general jurisdiction. It's the one that we discussed earlier, which is that the ACC is essentially at home here in Florida. The record doesn't support that conclusion that as a matter of law, the ACC is at home. As you know, the
We're
evidence...
still talking general.
We're still talking general.
Okay.
I can just run through some of the factors that are in front of the court. This is evidence in front of the court. The ACC, as I mentioned already, it's an unincorporated nonprofit association. It's organized under the laws of North Carolina. During its entire history, it's been headquartered in North Carolina. Its current headquarters are located in Charlotte. It doesn't own or lease property in Florida. It doesn't have bank accounts here, telephone numbers, mailing addresses. It's not registered to do business in Florida. It's not licensed to do business in Florida. It doesn't have an agent for service of process in Florida. It doesn't file a Florida tax return.
Yeah, I read the affidavit.
All those are right. All those are factors, Your Honor, and elements that are relevant to whether the ACC could be considered essentially at home here in the state of Florida. And so, Your Honor, we'd ask that the court deny the motion that seeks to establish general jurisdiction over the ACC. I wanted then to kind of move on to specific jurisdiction.
Okay.
You know,
That really gets us into Venetian Salami Part 1 and 2.
Part one
Venetian
and two.
Salami is
you know,
back
FSU
in the
claims
courtroom.
specific jurisdiction
Thank you,
exists under
Kerry
5 separate
Golnose,
subsections of Florida
for
law
your
statute.
incredible generosity. Thank
The
you
first
for the
is
super
operating
chat.
a business or a business venture in the state.
Please smash that like
The
button.
second,
Thank
which
you,
is in the
Kerry
same subsection,
Golnose,
is
Mr.
having an office
Florida
or
State
agency in
Seminole.
Florida. The third is committing a tortious act in Florida. Then the fourth is causing injury to persons or property here in Florida. And the fifth is breaching a contract in Florida by failing to perform acts required by the contract to be performed in Florida. So I wanted to go through each of those in turn. And let's talk first about the notion that the ACC is operating a business or a business venture here in Florida. FSU really makes two arguments to support this claim. The first one is that the ACC has conceded in the North Carolina case that it operates a joint venture with FSU. And then the second argument is, even if it hasn't conceded that the ACC nonetheless is actually operating a business venture here in the state of Florida. On the first one, this concession in the North Carolina case, you know, FSU leaves out a big chunk of what occurred in the North Carolina case in its argument. As this court is well aware, the ACC is suing the FSU in North Carolina. One claim in that case was the ACC's claim for breach of fiduciary duty against FSU. And in that claim, the ACC alleged that the members of the conference, including FSU, were in a joint venture with ACC and therefore owed the ACC fiduciary duties. FSU argued that there was no joint venture between FSU and the ACC, and therefore there could be no fiduciary duties that run between the two. Judge Bledsoe in North Carolina agreed with the FSU. And the judge held that as a matter of North Carolina law, there was not a joint venture. And Your Honor, Judge Bledsoe's order is in the record, and that's at paragraph 100 of his order.
Well, I have the Superior Court of North Carolina case, and I'm sure there are many that define joint venture. CanDev ULC versus SSTI Centennial. Let me give you the site. 2018 Westlaw 571758. And let's see if I've got it highlighted. It's not that different than Florida, and I have a Florida case which is 222 Southern 3rd 555. Just a minute. Yeah, this falls in the category of cases I've read but not highlighted or underlined. But I mean, there's an argument that can be made based on the pleadings that there is a business venture of some sort between FSU and ACC, whether it's a partnership, a joint venture, or not. I don't know that I need to go there, but I want to at least tell you, okay, in Florida, joint venture has 5 elements: community of interest in performance of a common purpose, joint control or right to control, joint proprietary interest, a right to share in profit, and a duty to share in losses. I think North Carolina is very similar to that. Let me see. Let me pull the North Carolina case up, see if Westlaw highlighted it for me. North Carolina didn't give me the benefit of detailed case notes, but my memory of reading the North Carolina laws, it's quite similar. So Does it make a difference whether or not it's a joint venture or not?
Well, Your Honor, the argument is simply that FSU has argued that somehow we've conceded that there's a joint venture. And that's simply not the case from the record of North Carolina. And our position is consistent now with the ruling of Judge Bledsoe in North Carolina, and now we're being consistent with that here. FSU is taking an inconsistent position. But I really think what the thrust of their argument is that FSU is operating a business venture here in the state of Florida.
ACC.
The ACC.
Yeah, I think that's the thrust of the
Yeah.
argument, and that's the only thing required by 48.1931A1.
Correct. And so, they really focus on two things. One, the grant of rights and the media rights that have been granted to the ACC by the members of the ACC.
Judge
and then how
Cooper,
ACC has,
it is quite apparent
sold
to
those
me
to
that
ESPN
Judge
to
Cooper
broadcast. And then they
has
also
been
focus on
reading
the ACC
about.
network, so I want to talk about
I
both of
think
those.
he's
Okay.
on the mark,
let's
like
first
he
turn into
knows
kind of the grant
the
of rights
details of
agreement
both
and then the
arguments
ESPN agreements.
much more now than he did
Let me ask this.
in
'cause
April. He knows the stuff inside and out. He's not
I'm
playing
just a simple
playing Columbo
lawyer.
anymore,
Just a judge.
in my opinion.
I was board certified and civil trial lawyer and A-rated, but I'm still simple. I like to get it down to the nub, and the nub appears to be the media rights dispute. Isn't that, now I know there are other peripheral issues out here, but isn't that the nub of the?
I agree with you, Your
Case.
Honor, that what FSU has alleged in its complaint at the very beginning is really what this case is that they're asking the court to interpret and construe the provisions, two provisions in two contracts. And that relates to the media rights provision, and it also relates to the withdrawal provision in the ACC Constitution.
Which
so those are
relates to the media
Right.
rights.
So those are the two things, and I agree with you, Your Honor, and that kind of, you're anticipating already some of the arguments that we've made in our motion, which is that that's really the nub of this case. A lot of these arguments and their allegations they make about jurisdiction don't have anything to do with those two, the operation of those two.
We'll see.
Right.
But isn't FSU arguing, but take all the other arguments, strip those away, and I'm not denying the validity of those arguments, but focusing on what I think is the main argument of FSU is that by exercising the media rights, ACC is conducting a business in Florida.
That is, I think, their main argument, and so I wanted to discuss why that argument is just
Okay.
is incorrect.
I'm not telling you not to discuss the others.
Yeah, I understand. No, and I appreciate, Your Honor, because with limited time, it helps. And
Mm-hmm.
and if the court doesn't want to hear and the argument
I
of the
know
other
your
section,
time's
if we have
almost-
time, we'll get to it. But
Your time's almost up, but
Yeah.
I have unilaterally extended it another 15 minutes.
thank you, Your
so
Honor.
go ahead.
So to understand that argument, we have to, I think, kind of walk through, and I'll do it as succinctly as possible. Walk through kind of how the grant of rights works and what that means, and what is being transferred up to the ACC, and then what the ACC and what then the ESPN is purchasing from.
Let me see
from
if I
the-
can
from
save
the
you some
ACC.
time.
Here we go.
ACC's position, or I think FSU's position, and I think also ACC's position as I read the affidavit of Mr. Terrio, is there has been a contract entered between FSU and ACC that FSU's transferred its media rights to the control of ACC and ESPN for home games. Home games are those played in Tallahassee or designated as home games. Like there can be a home game in Orlando, but that's an unusual circumstance. FSU and ACC has also transferred certain media rights to other games to ACC, and ACC has a contract with, you're going to have to help me, the other company, and I just forgot their name. Something media company from North Carolina.
Raycom?
Raycom.
Yeah.
So as I understand, ESPN, ACC is contracted with ESPN to broadcast FSU home games. Yes, ACC is contracted with Raycom to broadcast everything else. Now, if I'm being overly simplistic,
Yeah.
tell me.
I do want to talk about that a little bit, Your Honor, because
Okay.
I think that FSU wants to frame this, and I think FSU does want to frame this as somehow it's a purchase of home games, right? That's not what's going on. FSU.
Oh, really? So
yeah,
you don't
FSU,
own, you've not agreed with FSU to have the right to control the home games until 2036?
FSU and all the members of the ACC, under their grants of rights agreements, have transferred up to the ACC, have granted to the ACC their
I
media
get
rights.
that, but that's a
ESPN,
contract.
and then that's a contract. Then they bundle those all together and they market them. ESPN has purchased the right to broadcast all of the games of all of the ACC members, regardless of whether they're home games or not home games. FSU could play no home games, and ESPN is still going to pay the ACC, and then that money is going to get distributed out to the members.
ACC doesn't have the exclusive rights over home games?
It has exclusive rights over all the games.
So
FSU
did ESPN then spin off the non-home
No,
games
that's
to
not-
Raycom? Is
I-
that
All
I'm not
the
familiar
conference
with the
games.
sublicense to Raycom, Your Honor. I'm
No,
not familiar
if
with
Florida
that.
State is
Okay.
on the
What
road in
I'm more familiar with
Minnesota,
is the agreement between
ACC
the
doesn't
ACC
have those
and
rights.
ESPN.
ESPN doesn't have
ESPN
those
then has the rights to
distribution rights.
broadcast all the games whenever and
Conference
wherever they are
games.
played.
This lawyer's
So if
incorrect.
FSU played no home games, 0 home games, ESPN is still paying that lump sum to the ACC, and the ACC is still distributing that money out to the members of the ACC.
But
if FSU plays all home games, it's the same.
Okay, the reality is ACC has the media rights at a minimum to FSU home games, and the other members of the conference too. I'm just saying FSU for sake of brevity has the right to the media rights of FSU home games. And I kind of got on FSU before because they didn't define home games in the complaint. They defined it about 8 or 9 times now. So we all know how they've defined home games.
Yeah.
And ACC has entered in, y'all call it an agreement, I call it a contract. ACC's entered into agreement and contract, same thing last time I checked, but they entered into a contract with ESPN to broadcast those home games, and in return for that, receive from ESPN funds, money. And ACC distributes at least a significant portion of that money to the members of the ACC: Wake Forest, North Carolina, NC State, FSU, Clemson, Miami.
Correct.
I'm not going to try to name every one of them. There's a couple more I've missed, but
Thank you, Kenneth Klager, for your super
FSU's
chat.
focusing on
Unbelievable
not the Wake
generosity.
Forest home
Thank you,
games. They're
Kenneth
focusing on
Klager,
the FSU and the Miami
for
home
helping
games
us keep the lights
because
on here at Peek
they
Around the
take place
Corner.
in Florida.
Thank you, Kenneth Klager.
So
Appreciate
isn't
it
that
so
their
very
argument?
much.
Is that your business in Florida is securing the rights to home games played in Florida? I recognize maybe there could be a home game. I don't know if this game in Ireland, who's the home team? I haven't checked, but maybe there could be a home game outside of Florida, but the reality is the vast majority of the home games are in Florida. ACC broadcasts those in conjunction with ESPN. We don't know exactly the nature of that agreement because that's not been revealed, so I can't take that into account here, but we do know funds have been received. And I think I'm stating items that are consistent with Mr. Terrio's affidavit. And also those home games are those games, the FSU games for which ACC has media rights, are done under conditions and requirements of another contract, which is it's attached to the amended complaint, but it governs things like what the cheerleaders can wear, when the band can play, what the band can play, depending upon whether it's a bowl game or not. here's one that stuck with me, where you can conduct interviews. You must conduct interviews in a football game at a separate press room, but you can conduct basketball interviews on the court. And there are other rules and regulations. So ACC controls through its rules and regulations, which are a contract, many of the means and methods of how these games are played, and not just football, softball, basketball, track and field.
Judge Cooper has definitely read up on what is going on here. This is a different Judge Cooper than
soccer,
in April. He knows
volleyball,
the ins and outs of this.
etc. So how is that not a business in Florida?
Well, first, Your Honor, where we fundamentally differ from FSU is this notion that somehow they're purchased, that somehow the ACC, that home games have been the media rights to home games have been transferred, and that's what ESPN is purchasing. ESPN isn't purchasing FSU home games. What ESPN has purchased is the bundled media rights of the entirety of the ACC conference.
That is true.
In order to broadcast
Correct.
them nationally. It doesn't, and it doesn't matter under that, that whether FSU plays a single home game for the ACC to get paid by ESPN. It doesn't matter if FSU plays a single game in Florida for the ACC to get paid by ESPN. The revenues paid by ESPN to the ACC don't depend on when or how many particular games get played in any particular state. The value of the games is not that they're played in Florida or any other particular state, or that they're broadcast in Florida or any other particular state. It's that the games in their entirety belonging to the conference can be broadcast nationally.
Okay, so I've read Mr. Terrio's affidavit. Where is that in his affidavit? Because I don't see it.
That's
what you just, those facts you just told me, where are they in the record?
Your Honor, that's just common sense of how it is. It's not in the record one way or the
If
other.
it was
The notion,
common,
well,
sir,
I'm sorry.
if we relied on common sense, I would not have made FSU amend the complaint, because I knew then what a home game was, but they didn't allege it in their complaint what a home game was.
But Your Honor, they haven't alleged the notion that ESPN is purchasing home games. That's not in the record before the court either.
All right,
And
this
so,
is my summary of Mr. Terrio's affidavit. I'm going to give you the paragraph number, and you can decide whether or not that's an accurate summary or not. Paragraph 7. This is Mr. Terrio's affidavit, the ACC file. FSU, I'm summarizing, this is a lot of my words, so
and I have the affidavit here in front of me, Your Honor.
FSU and Miami entered into contracts called grant of rights. Paragraph 8, the grant of rights, and I've got in parentheses GOR. I can't get used to calling it GOR, so I'm going to call it grant of rights. Transfers media rights for FSU and Miami to ACC per the terms of those contracts. Paragraph 9, the grant of rights provides ACC, among other rights, the right to broadcast home and otherwise controlled games. Controlled games is not defined, but I take that to mean maybe bowl games or specially designated home games. And it could be that controlled games is in this massive amount of record I just missed.
It's just a game that you control the media rights to.
Okay.
Right. It doesn't have to be, for example, a home game. So if you control, if you're playing FSU
Orange
plays,
Bowl.
Not necessarily the Orange Bowl, but remember we were talking about, let's say, a game in Ireland, right? You may control the rights to that particular game.
Okay.
Right. So that's an example of that.
Let's do this. The grant of rights provides ACC, among other rights, the right to broadcast home games. I'm just trying to narrow it down. This is my comment. In other words, FSU and Miami are in a business relationship with ACC, which includes the transfer of their media rights to ACC. That's not the affidavit, that's my conclusion. I'm subject to being disabused of that, from that conclusion. Paragraph 10, ACC in turn contracted with ESPN to broadcast these games. Those aren't my words, that's the affidavit. Broadcast those games on ESPN networks and the ACC network. In return, ESPN pays ACC for these broadcast rights. Paragraph 11. He alleges that direct revenue generated in the game, I'm going to have to do this from memory, that's like ticket sales, concessions,
Everything at those stadiums, Your
those
Honor.
sorts of
It's-
things go straight to
Yeah,
the
food,
school.
parking,
Right.
box seats.
Yeah. It says, and then it says, hold on. Even if this is true, however, he does not say, and this does not alter other portions of his affidavit, and the now uncontested allegations of the amended complaint, that ACC is receiving income from ESPN on FSU and Miami home games. I will take that affidavit at its face value that they're not getting ticket sales, they're not getting the profits from the overpriced concessions. But they still are making revenue from the home games because they have the media rights that was transferred to them. Paragraph 22, and then they talk about there are bowl arrangements in Florida, and I'm trying to limit that to ones that are in Florida, and I think the affidavit perhaps did that. I still call it the Gator Bowl. Does it have another name now,
I still
Mr.
call
Lawson? Isn't it, is that the Tax Slayer Bowl? Is that the Gator Bowl, or is that one? That's the Gator Bowl?
It's
the
the
Tax Slayer
It's now
Bowl.
called, it's now called the Tax
Okay,
Layer,
well,
but I
For
think everybody
of-
in this courtroom, we can call it the Gator Bowl. You're
We
right.
can call it Gator Bowl. There's a bowl game, I think, in Tampa. There's the Orange Bowl in Miami, and probably a couple other. Admits to bowl arrangements. I have the number 13 in here, and I don't know if that's the number of bowls or not. So I typed this on Sunday, so I don't know what that means. So don't take that to mean anything. And it contracts for those. The contracts with the media rights include bowls in Florida, and pursuant to these bowl contracts, ACC receives revenue. And I think somewhere I read in one of these affidavits, I think of the bowl revenues, it gets about 90% from the Orange Bowl. I think I saw that.
Can I just walk?
Sure.
Sure. So for the bowls that are not the Orange Bowl,
Mm-hmm.
the ACC the ACC doesn't participate in the media rights for those bowls. Okay,
But it
so
still
it gets a piece of the direct revenue
It
generated.
gets
at
paid
the
by
gate.
the bowl committee
Correct.
organization.
Man,
Correct, that's
Judge
correct.
But it
Cooper,
receives money
he knows
through its media
details of
rights
a lot of
contract
this
with
stuff.
FSU
Like how they get paid by
and
the bowl.
Miami.
Judge
and
Cooper has
Clemson
studied
and
this.
whatever other teams might play in those bowls.
In
For
the
them,
last couple
it's
months,
good for
Judge
ACC
Cooper has
because
spent
it gets
time.
revenue. It's good for the other schools too, but it gets revenue for those teams playing in that bowl.
No, it doesn't get media revenue, Your Honor. That's not correct. The media rights to those bowls are owned by the bowl committees.
Okay,
So it doesn't participate. That's what I'm saying. It does not participate
so
in the media
FSU,
rights
so FSU
for those bowls.
All right. So ACC gets no revenue for FSU playing, let's say hypothetically, the Orange Bowl.
The Orange Bowl is different, Your Honor. That's why I said
Okay.
for the non-Orange Bowl bowls.
How about if FSU's in the Gator Bowl?
If FSU's in the Gator Bowl, the ACC gets a percentage of the gate ticket sales. It does not get any of the media revenue generated by broadcasting. that
What is
bowl.
to stop FSU from going to the Gator Bowl people and say, we're not playing in your bowl unless you pay us what you're paying the ACC. Don't pay the ACC, pay us. What's to stop them from doing that? I presume there's a contract.
They're a member of the
somewhere that
ACC,
stops that.
Your Honor. They're a member of the ACC, so they would be in breach of their, the Constitution of the ACC, since
Okay,
they're members
so-
of the ACC. So
so-
they'd be negotiating against their own conference.
Okay, so I don't disagree with what you're saying. I'm assuming there was a contract or rules somewhere that prohibited ACC gets revenue from bowl games in Florida, from which ACC teams play. And the main ones I can think of are like Gator Bowl and Orange Bowl, and I know there are some others, but those seem like the big ones. In Miami, in Orlando, it used to be called the Tangerine Bowl. Is that the Camping World Bowl now?
I think it is, Your Honor. Yeah. I
Yeah.
think it is.
I'm dating myself, but I know it used to be called the Tangerine.
Well, and the names change every couple of years.
Right.
So Your Honor. if-
Oh, I'm not, let me read one more thing to you, and then I'm done. In the last thing's paragraph 29 of the affidavit, the multimedia agreement is a contract under which ESPN receives the right to broadcast home and other select games. And then we go from 29 to paragraph 23, which is the end of the affidavit. We talk essentially about the confidentiality of the
Correct.
ACC contract, which again, unless somebody can persuade me otherwise, doesn't seem to be particularly relevant to this particular issue.
I agree with you, Your Honor, that the affidavit serves two purposes. One is relating to jurisdiction, and the other is relating to the confidentiality of the
Well, I'm
agreements.
assuming that you
Yeah.
could file the same affidavit in hypothetically another case.
Correct, and it's for efficiency. It makes sense to do it in both.
Okay, so.
So, Your
All
Honor,
right,
just
now
to-
that I've managed to extend your time, I'm fixing to extend it some more.
So,
You can
I
respond.
appreciate it. So, Your Honor, just to talk a little bit about the bowl games, because that's what we've been on. And so if you go back to Mr. Terrio's affidavit, there's five bowls. Let's hold the Orange Bowl aside for 1 second and talk about the others. And so as stated in that affidavit, the payment to the ACC from the organizers of those bowl committees, and remember, those bowls are organized by their bowl committees. They're the business community of the town or the city where the bowl is located, generally speaking. And we see the men and women that are in that committee, often at halftime, we see them down on the field, et cetera. So
Usually wearing a
colored jacket, they have a
interesting
jacket, right, they have a colored jacket. And I mean, I grew up in Miami, and so the Orange Bowl committee members would be down on the field with their jackets.
I'm assuming their jacket is orange?
It has been, but sometimes it's not orange. So it's just-
Okay.
yeah. But as stated in Mr. Terrio's affidavit, the payment to the ACC from the organizers of those bowl committees for those four bowls is minimal. They get a share of the gate, the ticket sales. They do not participate in the media revenues. And over the past 5 years, less than 1% of the ACC's annual gross revenue is related to what they get from those bowls. And then as he's noted in his affidavit, it's actually less than that because the ACC has expenses that it has to pay to the teams that participate in those bowls. So it's something less than 1% of its gross revenues are generated by those bowls. The Orange Bowl is an exception.
I take it this is a de minimis argument.
Correct,
So
exactly
Let me
right.
give you an alternate hypothetical. Let's say I own a grocery store in Jacksonville. I'm from Tennessee, always wanted to own a grocery store in Jacksonville. So I set up a store and I contract with the produce sellers in Jacksonville to buy produce from them. And they bring me all the lettuce and the onions and the collard greens and the mustard greens and everything else you can get. And I sell it in my grocery store and I don't pay them. So they can sue me in Florida, correct? Let me add one other hypothetical. Let's say this produce company is based in Florida, but they're actually from New Jersey, and they want their checks sent to New Jersey. Can they sue me in Florida?
Well, Your Honor, I don't know about the New Jersey aspect because but it would depend on what your contract says.
The reason I told you that
yeah.
is because the payment's not required
I
to be
understand.
sent to Florida.
Right, I understand, but I think what the court is really getting at is the connection point. right? Because you're asking, can I sue them can they sue me for failing to pay them? That would be a breach of contract or maybe unjust enrichment, or if it's not a contract. But that's the point about specific jurisdiction, that it has to be linked to your cause of action.
Right. I'm
So
running a business in Florida, and the issue of the prospective lawsuit by the New Jersey Produce Company is the fact that my business in Florida, I've incurred debt and I haven't paid it.
Right.
That's the connection, isn't it?
So yes, so it likely would be, but so the point here is, of course, you got to have a connection between your cause of action and what you're alleging for your basis of jurisdiction. So here, running a bowl game in Florida, even if you were to conclude that that's running a business operation in Florida, FSU's claims don't have anything to do with the bowl games. They haven't alleged a breach of anything relating to the bowl games. They haven't alleged that they haven't gotten paid for participating in a bowl game.
FSU's games, broad stroke, not everything, but broad stroke, relate to ACC's control of media rights and what happens to those while FSU's in, how they're managed, one, and two, what happens if
Judge
FSU
Cooper
decides
is
to
not
leave.
buying.
But FSU
Not
does not
buying what
allege that they're not
ACC
receiving
selling.
what they're entitled to under their contracts. So even
Aren't they
if,
alleged that those media rights are being mismanaged? I cite to you the Raycom, multiple pages on that in the complaint.
but Your Honor, so for example, the bowl game, right? So they're using that as a basis for saying they're operating a business in Florida. Their allegations don't relate, their allegations relating to the construction of those two provisions in the grant of rights, what was granted and what then would come back if they withdraw, and the withdrawal penalty don't have anything to do with running the bowl games. So that can't be connected to their cause of action. That's a way to backdoor in a notion of general jurisdiction through specific jurisdiction, saying I'm operating a business in Florida and now I can sue you for anything relating to that business. That's not how the specific jurisdiction works. Your cause of action has to be related to the specific activities that are at issue in your complaint.
Now we're talking about minimum contact.
Yes, we are. Yeah.
So I have found the quote from Justice Gorsuch for you. It is, you're correct on the name, but let me again try to state. Mallory versus Norfolk Southern Railway, 2023 Westlaw 4187749, U.S. Supreme Court, 2023. And this involved a personal injury plaintiff that sued a Virginia company in Pennsylvania for injuries sustained in Ohio and Virginia. So lots of different states involved. This is the case where there was actually an agreement the defendant signed to be granting jurisdiction in a particular state, and the Supreme Court affirmed that. But what he said, in referring to international shoe, I never thought 49 years ago or 50 years ago when I was in law school, I'd still be talking about the international shoe case. But here we go.
Madison v. Marbury.
Yes, I know. International shoe. The fact remains that, this is Gorsuch, not me. The fact remains that international shoe itself eschewed any mechanical or quantitative test and instead endorsed a flexible approach
The
focused on
Maryland
the
case
fair
did not
and
involve
orderly
a grant of rights. The
administration
Maryland
of the
case
laws, which
only
is the
involved an
purpose of the
exit
due
fee.
process
So it
clause to
wasn't
ensure.
as complicated, wasn't
Unquestionably,
as contentious.
too,
And Maryland just
international
negotiated
shoe
the
saw
exit
this
fee. Completely
flexible
two different
standard
cases.
as expanding, not contracting, state court jurisdiction. As we later put the point, the immediate effect of international shoe was to increase the ability of state courts to obtain personal jurisdiction over non-resident defendants. And that was an unlikely alliance of justices that signed off on that opinion, as I'm sure you know. And then we go over to You know this case. It's 2013 11th Circuit Louis Vuitton. I don't know if I'm pronouncing that right. Perhaps the people that buy purses can tell me if that's right. But I think that's what they sell. 736 Fed 3rd, 1339, 11th Circuit, 2013. And as you know, Florida courts rely extensively on federal courts for this due process or minimum contacts prong of Venetian salami. And then they give, what you were talking about. Specific personal jurisdiction cases, we apply the three-part due process test, which examines, one, whether the plaintiff's claims arise out of or relate to at least one of the defendant's contacts with the forum. Forum just means state. Two, whether the non-resident defendant purposely availed himself of the privilege of conducting activities within the forum state, thus invoking the benefit of the forum state's laws. And three, whether the exercise of personal jurisdiction comports
I'm leaving
with
the
the
studio. I'll be back in 2
notions
minutes.
of fair play and substantial justice. And then they talk about, as I'm sure you know, the Ford Motor U.S. Supreme Court case 2021. And I don't recall who wrote that, but the commentators say that case stands for the fact that the first prong, the arising out of or relate to prong, contemplates some relationships will support jurisdiction without a causation showing. They've taken that test and they've done this to it. They've broadened it. And this is 1991 U.S. Supreme Court. This isn't a 1960s U.S. Supreme Court case. And then it says, they call it the relatedness prong of the personal jurisdiction analysis considers whether there is an affiliation between the forum, the defendant's contacts with the forum, and the underlying controversy. And that's a 2017 U.S. Supreme Court, the Bristol-Myers case, 137 Supreme Court, 1773. So, what's your thought on all that? So I know we've jumped a little bit.
Yeah. So, talking about the Mallory case and the quote from the majority opinion of Mallory, the court is absolutely correct that when International Shoe, when that decision came down, it did expand notions of personal jurisdiction because, as the court is aware, we dialed it. If we kind of step in our time machine and go back to pre-International Shoe, state courts often had very restrictive rules that were in place that strictly limited the extension of personal jurisdiction by states. So unless you had, for example, situations where a corporation had registered to do business and therefore, as is in the case of Mallory, had submitted to, in that process, had submitted to jurisdiction of the state wouldn't have the ability to exercise jurisdiction over it. So International Shoe
was sometime in the 40s?
Yes, it was.
Okay, so as we all know, it was a big deal in the 40s to try to get to Indiana from Florida.
Correct, and International Shoe, the court is absolutely right. And it's giving us an historical statement that when International Shoe came down, it expanded the notion of what was permissible under the Due Process Clause. Now, we're all now familiar with that test. So I guess Justice Gorsuch is an historian, as we know, and so he's giving us some of the history of
I'm told a conservative,
and certainly interested in history and tradition, and so he's giving us some of the history and tradition of the Due Process Clause jurisprudence by his court, and it's particularly important because that case, if you recall the Mallory case, that's about a statute, a Pennsylvania statute from the 19th century. So kind of the historical context I think is important there to understand the evolution of that there. But the now familiar test, I'll call it a minimum contacts, and I'll get into that in a second. As the court is aware, there are many cases that find that due process does not permit the extension of personal jurisdiction of a defendant because it hasn't met, the minimum contacts have not been met. So then the fact that International Shoe expanded it back in the 40s, what was permissible and what was not permissible, does not mean that there's now carte blanche for the due process clause to extend to any case before the courts. We know that because there are plenty of cases where appellate courts conclude, no, this went beyond what due process permits, and you can't extend jurisdiction over that defendant there. Now, to talk quickly, just briefly about the connection point, there's connection at 2 points, because remember, in the Florida long-arm statute, it specifically and expressly requires a connection to the cause of action. So we have to look at it at both stages, both at under Venetian Salami, does this fall within the ambit of the Florida long-arm statute for specific jurisdiction? Because you've seen the prefatory part of subsection 1, it talks about causes of action.
1A.
Correct. And then, and I can read your language. And then we have the notion of minimum contacts. Kind of gets to reasonable anticipation, which has a connection element to it. And so I wanted to just go through that as well, because under the allegations that we have, and in the record that's before the court, if we're looking at the due process part of this, the ACC has insufficient contacts with Florida, and here's the test, such that it could reasonably anticipate being hailed into court here in Florida with respect to the claims that FSU has brought. And so just to, quick background or back up, ACC, it's organized in North Carolina, it's headquartered in North Carolina. The contracts at issue were entered into in North Carolina, governed by North Carolina. But here's a plaintiff asking this court to construe those contracts. And so ACC really had no reason to reasonably anticipate.
The plaintiffs would tell you what you've left out is the multi-million-dollar media business ACC is conducting in Florida.
That's a presumption. They're asking the court to go ahead and make that assumption. Right. That's their argument. That's their argument. Exactly. But here's what they base this on is that things like holding an annual spring advisory committee meeting here in Florida, right? Bowl affiliations that generate less than 1% of their annual revenue. That's a de minimis point. Right? That's all relevant to the due process analysis. Directing people to use a third-party merchandise seller over in Jacksonville. That's Fanatics.
Here's the problem. Your affidavit, Mr. Terrio, says there is no solicitation by ACC in Florida. Now, that seems to be at odds with the exhibit you just put in and what plaintiff said, but it apparently creates a factual dispute, not significant enough, in my opinion, to merit witnesses. But I just want to let y'all know I'm viewing that as a factual dispute, even though I don't know what to do with this affidavit, because there seems to be no dispute that ACC has a contract with Fanatics, and maybe the fine-tuning of it is that Fanatics does the soliciting of business, I guess, online, or maybe with other stores, but your contract says you don't solicit business.
Right.
I'm sorry, your affidavit says you don't solicit business.
Right, because if you were to go to the ACC website and you wanted to buy something, you'd just be directed over to the Fanatics, and you'd buy it through Fanatics.
Well, that's not a solicitation?
Whether you choose to buy it through Fanatics or not, you can go directly to Fanatics as well to buy it.
Okay.
So
let's say I want to buy.
But even if,
let's say I want to buy tape, Scotch tape that's made by the 3M company that's used to repair books because this tape has no acid in it. There's nothing in the glue that'll turn the paper a different color. I can go to the Scotch tape company and get that, or I can go to Amazon on their website and they effectively send me to 3M to purchase it. You name any of their other marketers, whether they're books, whether they're CDs, whether they're vinyl records, these are all little business people. They have, in essence, a reference on the Amazon website, and they get steered there. So Amazon's not soliciting business for their wares?
Your Honor, the case law is clear that even if you use a distributor located in Florida for your internet sales, that's not sufficient for minimum, to make personal jurisdiction. That's the
By
Hussar's
itself.
case.
By itself.
By itself. And then here, as the court has before it, there's in 12 months, $144,500 of revenue that the ACC has received from that. So that's even less than I would imagine the bowl game revenue would be.
Scotch tape doesn't
So
cost near that much.
you have to buy a lot of Scotch tape to get that.
No, I don't know how much Scotch tape they sell.
So, and you think of the other things that FSU has alleged here, that the ACC provides referees at ACC versus ACC games, or that the ACC promulgates uniform rules governing these games throughout the conference.
Okay,
And-
it's more than just providing referees. Let's see if I have this. This is either in the complaint or FSU's response. There's the bylaws. There's the Constitution. Let me look at FSU's response. You know what? I had that. Had it tabbed. Okay, ACC General Policies and Procedures, which FSU is required, and all the ACC schools are required to comply with, right?
That's correct. Those are the uniform regulations that are promulgated by the ACC that its members follow.
What if FSU, or well, let's don't say FSU, what if Wake Forest decides to not comply with it? What happens?
I don't know what would happen. I assume that there could be some type of claim relating to that if there was something legal that happened. But again, that would arise. But Your Honor, that gets back to the point of the connection between a cause of action and an allegation, because that would be arguably a breach of that contract. And so, if someone wanted to take a legal action, that would arise out of that contract.
Okay, so
So which is different than just kind of throwing that out there and saying, but I want to talk about this other contract.
I have a point to this, and I'll try to make it in a minute. ACC General Policies and Procedures. There's a concept in Florida called a parent agency. And for example, if the ABC Hotel company franchises its hotels to the Lawson Hotel Group, but they so micromanage the means and methods of operating that hotel through their franchise rules, the ABC Hotel Company is liable for the Lawson Hotel Company's negligence. I can give you the sites if you want them later, but that's the law of Florida. So when you manage or micromanage the means and methods of doing something, you take an ownership interest in it. So the general policies and procedures relate to, among others, FSU games, not just football, but FSU games. Among other things, they control where the appropriate post-game interview area for all sports shall be provided by the host sports information director. They don't leave that up to the schools. Post-game interview policy for sports other than men's and women's basketball, men's and women's lacrosse and baseball championship. All post-game interviews with coaches must be conducted in a press interview area designed by the host sports information director. So that's why I guess after every game, whoever the ACC school is, you see them come into what I call a press room or a press facility. You don't, I'm trying to think if I've ever seen an ACC coach interviewed after a game on the field, and I guess probably not. Basketball, though, I think They can be interviewed on the floor. There's post-interview policy for men's and women's basketball. All post-game interviews with coaches will be conducted in a press interview area. Well, I was wrong. It must be in a press interview area. There'll be a maximum 10-minute cooling off period, at which time the first available head coach will begin a 10-minute interview session.
You've made your point, Judge.
I guess that's for the coach to cool off from any last-minute calls he or she doesn't agree with. Post-game interview policy for baseball championship. Post-game reporter for officials' locker room. Cheerleading policy for basketball. Tosses, I guess that's when you throw somebody up in the air. Tosses will only be allowed when a total of 2 people are involved, i.e. only one person tossing another person into the air. The ACC controls how the cheerleaders toss each other in the air. In basketball, championships, that's what this is for. Olympic sport championship policies. Venue completion, bands, cheerleaders, mascot, and dance teams. Pet bands, cheerleaders, mascots, and dance teams are not allowed to attend Olympic sport championships. So I'm not sure exactly how you work that. Maybe it's ACC athletes that participate in the Olympics or in the Olympic trials, but that's covered. Guidelines and recommendations for Olympic sport championship. Championship host. When hosting an ACC conference Olympic sport championship, the host championship manager should be full-time employee of the host institution. Championship competition and practice. Now, some of this may be NCAA policies. I recognize that are incorporated by ACC, but it's pretty detailed. So that's not, the ACC controls the games, doesn't it, in large part? That not only it gets revenue from ESPN. I'm referring to host games because that allows me to, be more narrow in my focus. They get revenue from host games, whatever the sport happens to be, if it's a host game. Probably 90% of those are in Florida, unless it's a designated host game out of state somewhere. They get revenue from ESPN for those, and they control how the games are operated up to the point of how the cheerleaders are tossed in the air in some of them. So how's that not operating a business in Florida?
Your Honor, nothing in those uniform regulations that govern the ACC, the way the ACC members conduct their sports and other activities, has anything to do with the claims that the plaintiffs have put forward. And so we're talking about specific jurisdiction. And the Florida long-arm statute requires, whatever the basis is for concluding that it meets one of the enumerated statutory factors, that the claim relate to that. So to the extent they're saying, well, let's look at these uniform rules that get promulgated across the ACC, they don't make any claim relating to those rules. They just kind of throw those out there to the court and say, see, the ACC requires its members to follow uniform rules.
Arise out of or relate to.
There's
Louis Vuitton versus Missouri, 11th Circuit.
Yes, Your Honor. There's nothing that arises out of those the rules that we just went through in terms of cheerleading, basketball, where the coaches can have their post-game press conferences. There's nothing that arises out of those that relate to their claims relating to the grant of rights provision or the withdrawal provision.
Is it
in
the business of the ACC to conduct in Florida sports competition, publicize that competition, authorize sales of sports memorabilia? Now that your document mentions it, I think I can.
Well, we're going to be here all day, so.
And control those sports events. I think a television producer would probably tell you all those things have to do with the appearance you give in the sports presentation, how it looks, how it comes across to the public, whether it turns people off from watching, etc. If you have a coach who's cussing up a storm 5 minutes after a call, that's probably not good for marketing that event, etc. FSU would probably say that's the business, and they would also say that they've alleged two things, at least two things. These are their words. I'm not saying I agree with them or disagree with them, because I've not seen evidence on anything. I've seen allegations that ACC has mismanaged the sports business it's running in Florida for FSU, and it's mismanaged, and it could be by mismanagement, it could be collecting a lot more money than it is, but it has mishandled that. And that if somebody wants to leave, it's valuing that business at too high a value to the point that the purchase price for withdrawing from that business is punitive and not compensatory. Again, this is a long way down the road. I understand that, but if you're in a law firm and let's say you don't have a contract, you're in a law firm. There's not a lawyer in this room who hasn't been in and out of a law firm that I can think of. Your compensation, if you're an equity partner in that law firm, is either by formula set by contract, but the formula set by contract is supposed to be based upon a reasonable valuation of that partnership interest. If Mr. Lawson left his law firm and his partner said, well, we're not paying you anything, but you have to pay us $1 billion for the right to leave and take your business, which is worth it. We think your business.
Chris Nee is reporting at 247. Cooper is pointing out that Florida State is alleging ACC has mismanaged the sports business they have their hands in Florida. Florida State value could be greater than what the ACC has derived from them to be distributed, spitballing on Florida State's argument side of things.
What they're asking you is to give a declaration of the meaning of a contract. So if the court does that, that's kind of where this case is. They have an agreement, but the valuation, the sale of the media rights by the ACC or the broadcast rights to ESPN is a bundled sale. It's not sold on a member by member basis. So to stay with an institution that you had picked, Wake Forest, the ACC doesn't sell to ESPN the broadcast rights for Wake Forest. It doesn't sell to ESPN the broadcast rights for Clemson or FSU or UNC or Boston College or any of the other member institutions. It sells a bundled right. And so that's why, you'd ask, are they operating a business in Florida? No. What they do is they have a conference of members across the East Coast, up and down the East Coast. And for purposes of the media rights, they bundle those rights and sell them in a package. They sold them to ESPN, and ESPN pays a lump sum for them. So
Okay, I get what you're saying. So I want to take about a 10-minute break, and then what I want to do is give FSU about 15 or 20 minutes to start its argument. This is taking a lot longer than I thought, but it's a very important issue for both sides. And since I actually have read everything, I still have questions. It's a Socratic dialogue, at least in my opinion. It might not be the opinion of everybody in the room, but that's where I am. And I want to hear some of the defendant's position before they have a chance to, quote, sit at lunch and figure it all out without being told that. But I'm still, don't worry. If you need time, I'm going to give you time.
Thank you, Your Honor. Appreciate it.
Okay. Let's come back in 10 minutes, like about, according to that clock, about 20, I'd like to start about 25 after the hour. We're going to go to lunch about a quarter till 12 or so. But I'll tell the court reporter, don't worry, we're not going to start without you. So you take whatever time you need.
Okay, we're going to open up the phone lines. If anybody wants to give us a call on what you think so far. First of all, let me thank everybody who's given us a super chat and everything else. Holy smokes. Michael Monk, thanks again for your super chat. Kerry Gold knows. Please smash that like button. Thank you so much for your generosity, Kerry Gold knows. And Kenneth Klager. Holy smokes. Thank you, sir. Thank you for your incredible generosity. And Donnie McNerney. Donnie McNerney is gifted a membership. Holy smokes. So, to whoever who was granted that gift membership, and Donnie, you are hereby knighted cloak and dagger once again. It has been over 2 hours. Well, no, it hasn't been that long. Excuse me. I don't know. It's been close to 2 hours. It's been long. And the ACC is still talking. Judge Cooper is still asking questions. And it was only supposed to be 30 minutes for the ACC, 30 minutes for the Florida State in regards to the question of jurisdiction. The phone lines are now open. 763-260-1333. 763-260-1333. Let me know in the chat room. Let me know in the chat room when they begin again. Now, the ACC lawyer is correct on some points here.
Call from
Ryan Thomas.
Ryan Thomas, the floor is yours.
Well, Greg, I'm listening or was listening to these arguments as I'm going through a PowerPoint deck here at work, and I can't determine which is more mind-numbing. I have a hard time buying these arguments that it doesn't have essentially doesn't have a trade or business in Florida. Some of the arguments used by the ACC attorney, for example, like a tax return, are kind of disingenuous because those aren't necessarily required in some instances for a nonprofit organization in the state of Florida. So I think his argument's a little disingenuous there. And it's interesting, Greg, because when you look at, I was looking at this issue for the Pac-12 and looking at this in all the Pac-12 states during the Oregon State and Washington lawsuits. And this type of organization is considered, in basically in all the states, at least the Pac-12 was in, and I know this isn't connected to the ACC, it's not, but it's a similar issue. And under a lot of state laws, they treat these unincorporated associations or businesses as residents in the states where their members reside. And so I kind of have a hard time, and that's at least for legal purposes, so I sort of have a hard time believing the ACC's argument. I don't think it's necessary. As Jamie would say in Arkansas, that dog don't hunt. So, I mean, it's sort of hard for me to really buy that. Now, when they start going into the bull stuff, that's all irrelevant BS. It's all irrelevant. It really comes down to the fact that, the ACC network, which is, partly owned or something that the ACC gets a benefit from, they've got camera crews down there filming the games that, for FSU in Miami in their stadiums. And I mean, that's, the agent case, they're doing the business there. They're conducting the business there. So, I mean, they can't have their cake and eat it too here, Greg.
Yeah.
So, I mean, that sort of, I just think it's a ridiculous argument, and I think Judge Cooper is not gonna, he's not gonna have any of it, and it didn't sound like he was having any of it.
Yeah.
But I will say this: I'm glad that he brought up the grocery store example, because it just reminded me that the PATC community is coming to raid the ACC's kitchen. So, I mean, we're coming for your fridge. Hide the women and children. But anyway, Greg, I think it's going to, I don't think that this, now, because this is going so long, I guarantee you that there's probably going to be another day for this to continue, but I don't know when that will be scheduled to get on the docket. But this is sort of the song that never goes, that never ends. So it's sort of a painful feeling, but great job on the show. Certainly there's wild, rampant, crazy speculation all over the place.
Yeah.
But I think, this is kind of interesting here, and I hope if there's any Florida attorneys out there, it'd be great to have them get on and kind of explain their thoughts. But anyway, thanks for everything you're doing, Greg. Keep up the good work.
Thank you, Ryan. Appreciate it, sir. Kerry Gold Knowles. Thank you so much, Greg. This is where they're going to bring up the prior ACC commissioner and how he did not act in the best interest of Florida State. They broke the contract by doing that, and that's why higher ups at Florida State think we are getting out and paying zero. Thank you so much, Kerry Gold Knowles. That is part of the Florida State's pleadings. They brought it up. Florida State has brought up how Swofford did not act in the best interest of the conference, the best interest in Florida State, when he cut Raycom in on the deal. And they brought up more examples than just that. Thank you, Kerry Gold Knowles. I do appreciate your generosity. Once again, holy smokes. Thank you so much. I do agree with Brian Murphy. Brian Murphy, ACC attorney, says league does not sell Florida. I shouldn't say I agree with Brian Murphy. I agree with the ACC attorney on this point. The ACC attorney says league does not sell Florida State's or any other school's rights individually, but instead as a collective bundle. That is something that the ACC attorney got correct. I don't think it makes any difference, though. I think it's not impactful to the argument. And I think Judge Cooper understood it, but he was like, well, so what? But now when the ACC tries to sell the distribution rights of the conference, when they bundled up everybody's content, it gives the ACC more leverage, more value when you combine it all together. But I think Florida State is going to argue with this point. It is true that the ACC does not sell Florida State's individual rights, their rights individually. But the people who are buying the bundle from the ACC, and in this case was ESPN. ESPN has valuations of Florida State, of Clemson, of Wake Forest, of Syracuse. They value them individually, and then they value them together. Florida State has a big rivalry game with Wake Forest. They don't, but I'm just putting up an example. If Florida State and Wake Forest had a big rivalry game that was going to bring in viewership, then Wake Forest's individual valuation would get bumped up a little bit higher. Just an example. So I think maybe the Florida State lawyers are going to say yes. The whole thing is sold collectively, bundled, but our valuation is much higher than everybody else, or almost everybody else in the ACC. So that in particular, the ACC lawyer got correct. What the ACC lawyer got absolutely wrong, and I believe he's going to get roasted on a steak by the Florida State lawyers. The Florida State lawyer, I think, is going to come in there and say, The ACC doesn't own all of our games. Remember, the ACC lawyer kept saying, we own all the Florida State games, all the Wake Forest games. No, they don't. No, they don't. The ACC lawyer was trying to make a case, really doesn't matter if Florida State's home or away. ESPN's going to distribute the game and ACC has those media rights. That is not true. The ACC owns the conference games. They don't own Florida State playing an out-of-conference game, being on the road against some other school. Florida State at Ann Arbor, Florida State at TCU, Florida State at Texas. Those games are not owned, obviously, they might get distributed by ESPN, but they're not going to be owned by the ACC. So that was incorrect. I think Florida State's probably going to correct that. Again, I am not a lawyer. I'm just a fat guy from Minnesota. I think there is nothing. Judge Cooper is being polite. He's being thorough. It's obvious to me, and I think everybody else who's watching this, that Judge Cooper has a good grasp of the issues, the details. I think it's quite obvious. Judge Cooper is going to dismiss, is going to reject, he's going to absolutely reject the ACC's motion to dismiss, which is not a surprise. But after listening to Judge Cooper again, I think he's given, of course he's pushing mediation. And I think he's probably going to mention it again. Now, they do have a mediator, but I think he's going to push that again. I don't think this is the third time we've heard Judge Cooper preside with the ACC lawyers and the Florida State lawyers in the courtroom. I don't think he's ACC friendly when it comes to the arguments that the ACC is doling out.
Call from ABO Prep.
Soap is on the line. Go ahead, Soap. The floor is yours. We're going to hold you about 5 minutes because they're going to come live again. Go ahead, sir.
Yeah, I'll make it short of that. Greg, I concur with you. I think that the judge is not going to dismiss the charges. This means that the trial will go ahead and that discovery could possibly occur with ESPN. I don't believe that they want that at all. And I think if you look at Josh Pate's tweet of the other day, the big pounding sign is ESPN coming and dropping the bomb and saying we're not going to go ahead and renew the ACC. We're getting out of the ACC business. They don't want to have anything to do with discovery and letting those contracts out. If that were to occur, then my theory might very well hold that I've held to for quite some time, that the dissolution is going to be quickly before the end of the month. If they were able to dissolve the conference and there was no contract with, or no pending contract with ESPN, then they could simply take those 7 or 8. It would be 8 with Notre Dame. Those 8 group school of 8. Louisville might make it 9, and put a co-op together for a league, which means that the distribution rights or the broadcast rights for each of these schools would go into a pot. You know, SEC, ACC, I'm sorry, SEC, Big Ten, and the Big 12. They would take all that money, put it together in the pot for maybe 3 or 4 years, so that everybody would get the same amount of money for their distribution rights for a set period of time. That would be the new league. It would actually be a conference. They would all be members of the other league. There would be a conference that would be splitting those funds. And as to Immaculate's comments about the legal process, the other schools suing the schools that decided to leave, he's right about that. But if there was no pending contract, if the ESPN had said that they're not going to be part of this, then I don't think there'd be any case for that. That's it for me, Greg. Thank you so much for broadcasting this. I greatly appreciate it. I find it fascinating, but I've got to agree with you. I don't think that they're going to make the changes. And if you look at yesterday in the what you showed in section 214, they were very specific, saying that ESPN was part of this, and that the ESPN rights are tied to the universities, and they're independent. The rights go with the school if they leave. They pretty much said that in that section. So thanks again, Greg. I appreciate it.
You got it. Appreciate it. Thanks for the call, sir. So this is Chris Nees reporting. Chris Nee, 247, Florida State. He's in the courtroom. He's in the courtroom. Summing up much of the last 70 minutes. The ACC says ACC bundle media rights and sales package to ESPN for a lump sum. Cooper pushing back on Florida State home games value, etc. This is taking a lot longer than I thought, Judge Cooper. According to Chris Nee, the ACC's argument of bundle, pay regardless of home or away, no home games still paid, seems to be getting torn apart as basically nonsensical. Also, when the Florida State lawyer said, when the ACC lawyer said that Florida State would get paid even if there was no home games, well, according to the regulations of the ACC, you got to have so many home games, and you can't go over those home games unless you get an exemption. So even that was not correct by the ACC lawyer. Florida State's going to play 7 home games most of the time. Crazy Horse. So since the rights are bundled, does that prove Clemson's argument about they take their rights when they no, it doesn't. It's just that is how the ACC sells the distribution rights. The reason why there's a grant of rights is it gives the conference more leverage in when they negotiate with potential media partners. If you bundle the content together, then the media partner knows that this content's going to be there for them for however many years the distribution rights are for, and the conference will get a little bit more money if you sell it together. It's the same thing with Tier 3. We've learned about the Big Ten network, and the SEC network gets a lot more juice out of those third-tier games, when they're bundled together in a network to be sold or be distributed, to have ad buys on Big Ten Network. You got subscription model, subs, ad money. These conferences have learned if you bundled certain content together and sell it, you get more money out of it instead of going individually. The Longhorn Network, there was not enough live content for the network to be able to get the ad money coming in to sustain that payment to Texas. So ESPN wasn't getting what they wanted out of the Longhorn Network, and Texas wasn't getting what they wanted because nobody was watching it. They were not getting the exposure. Texas A&M's baseball and softball were getting a whole lot more exposure than Texas baseball and softball. So there are some fundamental stuff. They're back. Okay, thanks, guys. There is some fundamental stuff that they got wrong. ACC.
So in Leon County, they telecast 216 games this year. Just this year, since August, 216. When
Is this ACC Network and ESPN
correct
together?
From the studios at Florida State. So back again to first principles. We are here on a contract between FSU and the ACC. They talked a lot about bundling. Bundling's irrelevant, Judge, because the only issues here are the home games of FSU. When FSU goes to play at Wake Forest owns that game. And when
that sounds just like my phone. So who took my phone?
And when FSU goes to play at Ohio State, ESPN has no rights at all. Why? Because Florida State's not at home. I'm going to bring you back.
So FSU plays an out-of-conference game.
Correct.
Okay, let's say FSU plays Florida. So how's that game?
Well, because
covered?
ESPN has
They're playing at Florida.
I know, but because ESPN has SEC, ESPN still has it.
Does ACC get any funds from ESPN if the game is in Gainesville?
No.
Or FSU game? Do they get funds from ESPN if the game is in Tallahassee, i.e. a home game?
Yes. Yes.
Okay.
So, and you have to keep in mind what you found on the very first principles. Again, media rights means home games. For the contract between FSU and ACC, that's it. And I'm going to read for you paragraph 12 of our amended complaint, second amended complaint, which basically quotes the ACC's complaint.
Okay, hold on a minute. Let me find and make sure I'm. Sorry
No
to the
worries,
TV people for hitting the mic. I think I'm at it. What page is it?
It's page 4, paragraph 12,
Page 4, just a second.
and it's quoting
Page 4, paragraph 12. All right, I've got it.
paragraph 12. The ACC contends the grant of rights is a written contract between FSU and the ACC, in which FSU granted the ACC its media rights, with media rights being defined as rights are for home games, and a home game being a game which is either played at a FSU home location or in which FSU has designated the home team. Those are the rights. If you read the paragraph immediately above that, Your Honor, in the ACC's complaint, they say this is a dispute, involves a dispute over where the grant of rights, an amended grant of rights, granted Florida State's media rights to the ACC after the ACC withdraws from the ACC and through June of 2036. Again, quoting North Carolina's ACC's First Amendment complaint, I would also quote paragraph 178. So the answer is
Paragraph 170?
178 in footnote 1 on that same page, Your Honor.
178 of your opinion?
No,
I mean, of your...
stay on the same page you were just on.
Okay.
The footnote at the bottom of the page refers to
All right.
paragraph 178
Of the ACC,
Yeah, so
a First Amendment complaint.
so these are the ACC's words.
Okay.
And you know what, Judge? They're right. This whole case is about the home games of Florida State and who owns them. This isn't a dispute about bundled rights and what happens at Wake Forest. It's who owns FSU's games. And our complaint and all these affidavits make it very clear those home games are played on the dirt and on the wood and on the rubber tracks and on the baseball diamonds here in Leon County. They're not played anywhere else. And there's another component to that, Judge. The athletics is supplied under the bylaws and Constitution. The media gets transferred under the grant of rights. And our affidavit, again, unrebutted, is that Florida State spent $10 million to perform that ACC joint venture, to build a studio, to broadcast and televise the media rights, which are the sole and exclusive issue in this case. Florida State paid that money. Florida State produced and broadcast 216 games from those facilities that it built, and Mr. Kander made clear in his affidavit that we built those for the joint venture that the ACC admitted to at page 62 in the transcript of this case. Your Honor, that is a business venture. That is a common enterprise. That is a common venture. That is business for pecuniary gain. Doesn't matter how you slice it. It's a business to make money, and it makes a lot of it. It makes billions. So it's a real business, and it's real substantial. So with respect to your questions, Your Honor, on specific jurisdiction under 1A1, that is a business venture being operated. The athletics, the 217 home games played by Florida State down the street, those are the athletics that are being provided. And almost all the cases in Florida don't ask, where was this contract entered? They say, where was the sausage made? Where were the services provided? And where were they supposed to be provided? Your Honor, it is beyond peradventure that the only place that a Florida State can provide a home game is in Leon County. That's it. That's the only place they can do it, and they built an empire to do it, and they're doing it. And if you drive by Doak Walker Stadium, you see it.
Doak Campbell.
Doak Campbell Stadium. Doak Campbell Stadium.
That's okay.
You see it. You see it at the basketball facilities. You see it at all 17 of those facilities that they built. And they bring the cameras over there, they bring the crew over there, and then they televise it. And yes, Your Honor, the ACC collects a whole lot of money. They collect a whole lot of money. They take their cut off the top, and then they distribute it down. So if you look at the case of Sutton, if you look at the case of Capilla, those cases
Is Sutton the dog case or the golf case?
The Sutton is the golf case.
Okay.
That is a case in which a golfer provided the labors, and the outside representative, essentially an agent, did nothing in the state of Florida. and claim brought on the contract was deemed to be connected to the business venture that the foreign entity was doing outside the state.
So let me ask you this, Mr. Rush. Do we know whether ACC's revenue from ESPN is tied to viewership numbers of the games? In other words, how many people are watching these games? Now, I haven't seen that anywhere, and if it is somewhere, I presume it might be in the contract between ACC and ESPN, which at least I've not seen.
Your Honor, I have not seen it either, and that's a bone of contention for us, as you might imagine.
At this point, it's not known whether the amount ACC receives varies depending upon viewership.
My understanding is, no, it doesn't. And that's
Okay.
part of the rub as well. In other words, the ACC set level of pay back in 2010, and it's increased by rote at 4.5% over time, and it's woefully undervalued. So in other words, the amount that the ESPN pays the ACC is fixed. What's not fixed, Your Honor, is the amount ESPN can make from the Florida State games. There's no cap on that. And there's no cap on what Raycom can make.
So I guess that's a gamble on the various teams from ESPN's side, what the various teams in the conference are going to do, because there have been some years that Wake Forest has gained a lot of, at least, I would say, some interest, because they had, as I recall, a really good quarterback that later ended up his last year going someplace else. And, there are other examples, other teams. Miami has had some very good years. Clemson's had good years. FSU's been up and down. And then I don't know how the sports relate to each other. I assume football is the largest income producer
It is, Your
among
Honor.
the sports.
It is, Your Honor. And what happens is that evolution over time, the conferences with more better teams gets more money. They generate more revenues. And so the game today is, how many good teams can I get in my umbrella when I go to see ESPN? The more good teams you have, when I say good teams, I mean successful football teams. The more successful football teams, the more money you get.
Mm-hmm.
And then the better Doak Campbell Stadium you can build, and the better studios you have. It's a self-fulfilling prophecy. But I think you've recognized, Judge, that Mr. Tarrio's affidavits in paragraphs 8, 9, and 29 say the same thing. It's all about the home games. You've been through that before. So it's the home games of FSU. So we're here, and this litigation doesn't involve anything else. The only content that's being provided under the grant of rights agreement is the FSU home games. That's it. That's all FSU can give. They can't go to North Carolina and give ESPN that game. They can't play at Wake Forest and give ESPN that game. They can't play at Michigan and give ESPN. The only game they can give, make, and produce, soup to nuts, cradle to grave, is the one down the street. And they do it. And they do it well.
So if it's a bowl game like FSU and Georgia, that's considered differently than if FSU were to play Georgia in a non-bowl. Let's say FSU played Georgia in Tallahassee. That would be looked at differently than if FSU played Georgia in a bowl.
Correct, because the sponsor, the person who puts together the bowl game, is neither FSU nor Georgia.
Mm-hmm.
The person that puts on the game in Leon County ain't anybody but FSU.
Mm-hmm.
And all their money goes into it, and they build it. And then they film it, and they broadcast it, and they produce it, and it's done under the name of, under the golden arches of, the ACC network. Your Honor, that is a business, pure and simple, And it's a big one. It's a big one. And there's not just one of those in the state of Florida. There's two of them. There's two of them. And on top of that, beyond the home games of the ACC, there's another 100 games that are played here by these teams in their facilities. So between Miami and Florida State, there are more than 400 home games played every year.
At all the different
All the
sports.
sports. That's more than one a day. The question, we'll get to general jurisdiction, is whether there is continuous, systematic, and not isolated action in a state. And if a game a day isn't continuous, systematic, not insubstantial action, then I don't know what is.
So can you have general jurisdiction in more than one state?
Yes, you can, Your Honor. What they'd like what ACC would like you to believe that home means only where I'm incorporated and only where I have my ivory towers. It doesn't mean that. Because I'm going to quote from their brief, Your Honor, to tell you what it means. These aren't my cases. These are theirs. Page 4. Engaged in substantial and not isolated activity. Continuous and systematic general business contact. And the statute of Florida, those are the quotes from their brief. Statute in Florida is just that. Section 2 is general jurisdiction. And the words of that one are substantial and not isolated activity. So our argument here, Your Honor, but not to get to general jurisdiction, just to stick with the specific jurisdiction under A1A, they have told us in paragraph 11 of our second amended complaint that the dispute is over the media rights to Florida State's home game. That's what this case is about. We seek a declaration that they don't own them. There could not be a more closer connection under the specific jurisdiction statute than that. And that's just one of the statutes we go after. The second one we go after is the case you were thinking about, was Gallant, the office, where they found that the person's home was an office. And Your Honor, our argument there is, again, very straightforward. It's that the studios that Florida State spent $10 million to build and then slapped the ACC network logo on the walls of, and then wears ACC network logo, is a place of doing business. That's the definition of an office under the Black's Law Dictionary, is a place of doing business for the ACC network. And business is done there every day, all day, all day. 216 broadcasts out of that office. We also maintain that they've committed a tort within section, and the tort being the alleged antitrust violation, that they committed a tort under 48-193-1A2. We've also maintained that they've caused an injury to a person or property in the state while engaged in solicitation. And Your Honor was exactly right. Whether they did it themselves or they did it through an agent or an apparent agent, Mr. Londot's affidavit establishes in no uncertain terms that they were soliciting at the time they were breaching the contract with us to exclude us from the operations of the ACC. But each day. Finally, Your Honor, breaching a contract in this state by failing to perform acts in this state, the Stomar case. So, Your Honor, what we would say is there's 5, 6 different specific jurisdiction statutes And with regard to connectivity, we hardly got to it, but that means under the Black's Law Dictionary that it arises from the transaction connected with the activities of the party in the state. The activities of the party in the state are the exploitation of Florida State's media rights, which are the home games and all the athletics that are played by Florida State in this state. Causal connection could hardly be more profound than that. Now, that's the specific jurisdiction, and each one of those statutes has been satisfied, and quite frankly, the evidence hasn't been contradicted. The ACC has said in different places that this is that the ACC and Florida State are a common venture, that they're a joint venture, that they're in a partnership. It doesn't matter. All it needs to be is a business venture, and it's a big one. It's a real big one, and it has to do with peddling Florida State's media rights. In this litigation, that's the only reason it was brought, was over Florida State's media rights with respect to it leaving the conference. So the connection is indelible. Now, with regard to general jurisdiction, Your Honor, we would say just the actions of the ACC since 1991 with regard to Florida State and the 200+ athletic contests that Florida State puts on every year in their home facilities would be continuous and systematic contact. Then we would double that when you add Miami in 2004. Mm-hmm. Then we would say, okay, you've now done this systematic and substantial, continuous and general business contact in 2 different counties to the tune of, in their words, hundreds of millions of dollars. And then you add on that you come to Florida to also, and what I see from that document that was filed today, 13 solid months of selling goods, your merchandise, out of Jacksonville, Florida. Every day. That is systematic, engaged in substantial and not isolated conduct with continuous and systematic general business contact. So now we've got 5 contracts with different Florida entities to render services strictly in the state of Florida.
Do you know how the revenue with, I'm going to take solicitation out of it and just refer to the sale of goods through the Jacksonville company.
Yes,
I forget the name, but the Jacksonville company.
Right.
Do we know what ACC's share of revenue is and how it's divided with FSU and other schools, if it is?
I have to take at face value the document they've shown, and what it says is
Oh yeah, that's right. This is what they get, isn't
right.
it?
They say, according to this, $144,000, $144,503.97.
All right, and we don't know how much of that goes to FSU, Miami, or other ACC schools.
We do not, Your Honor.
Okay.
You might presume it's divided equally, but what I'd say is more important, Your Honor, is this is not offered as a sole basis of general jurisdiction, but what I would say is look down that left column, Your Honor. The month.
June.
You're starting with July at the top.
And it goes to June.
July. It's got a July, and it starts with dollar figures that look like they mostly grow. July, August, September, October, November, December, January, February, March, April, with slots for May and for June. I describe that as continuous. I describe that as systematic. I would describe that as pecuniary. And this is, Your Honor, on top of 2 different ACC networks and on top of the athletics that Miami and Florida State provide on their own nickel. So if you're asking the question, Your Honor, what services are being offered under the Fanatics contracts?
I'm going to have to
they
leave
are
the
services
studio
being
for a few
provided by
minutes.
Fanatics out of Jackson.
I'll be right back.
So let me ask you this. Let's assume that you passed the hurdle number 1 of Venetian salami And at a minimum, it's 48,193, 1A1.
Yes, Your
And
Honor.
1A1's operating a business. Then we go to what I say, part 2 of salami, and that's minimum contacts. Some people call that the federal due process test. There's some other names. Louis Vuitton has a 3-part test, which is 11th Circuit 2013. I don't think that there are some other tests. I think that the U.S. Supreme Court perhaps has discussed some of these tests, but I don't think they've altered the
Powered by WCTV.tv. Your news starts now.
Coming right up on Eyewitness News at noon, voters in Georgia are casting their ballots today as the primary runoff elections have officially kicked off. We'll have more on the polls and the candidates in the races coming up. But first, help is finally here. President Biden has approved federal aid to help the Big Bend recover from last month's tornadoes and severe storms. Thank you for joining us at noon. I'm Lenitra Bennett. This is such great news for so many in our area who've been hoping, praying that this relief would come. Leon County residents can now apply for individual assistance, things like grants for home repairs and low-cost loans. President Biden's order also includes relief funding for local governments and nonprofits in 11 North Florida counties. 3 tornadoes tore through Leon, Gaston, and Jefferson counties on May 10th with winds over 100 miles an hour. They devastated many neighborhoods in Tallahassee. Hundreds of homes and businesses were destroyed or damaged. The city estimated more than $50 million in damage, not counting unincorporated Leon County. So many thousands of people will benefit from this funding. Now here's how you can apply. You can go online to disasterassistance.gov. You can call FEMA at the number on your screen, or you can use the FEMA app. We have all that information inside this story on our website and our WCTV News app. Now, that is good news for those tornado victims.
It is. I'm so glad to see that because, you know, I know a lot of folks have been anxious and waiting for that, and hopefully it should be good help.
Yes, and of course, we don't want to hear any talk about any more tornadoes or severe weather.
Well, good news, I don't have any.
Okay,
I don't have none of that.
Sounds good, Josh.
Absolutely, and as you head out the door today, what are you going to see? Well, you'll see a good mix of sun and clouds out there. Here's some live views across the Big Bend and South Georgia as of the noon hour. I don't see much in terms of any rain out there. We'll check in on the radar picture. Temperatures, of course, are on the climb. A lot of us now in the mid to upper 80s. I see 87 on the board in the capital city, 84 in Thomasville.
Okay.
Hi, I'm Victoria Missick, and I teach.
So did they go for lunch? Did they just announce they're going for lunch? No? It just cut off, huh? I had it in my bedroom. I had it on, so when I went in there, checked on my mother. I saw that it went commercial, and I'm like, "What?" It did not sound like they were gonna. They were gonna break for lunch at, I believed, it was either 12:45 or 12:15. But then when it got to 11:45, they were still going. So I thought I would have until at least 12:15. It's WTXL. WTXL is the other one. Tracy's saying it's just cut off the midday news. Chris Nee says a lunch break is coming soon. Purposeful availment component is what the judge is asking Rush, the Florida State lawyer, to define. A non-resident ACC entered into contract with Florida State University, for substantial services to be performed in Florida. Rush, the Florida State lawyer, states Swalford sitting down with Florida State in Florida to sign into contracts the Gore would satisfy the above. Tracy believes WCTV should be back at 12:30. Thank you, Tracy. Supposedly they're going to be going for a lunch. Send me the link. Oh, there it is. I have it on WXTL. I did get the link, but right now I'm just getting this is what I'm getting. What am I supposed to hit?
Call from
Immaculate.
Yes, sir.
Okay.
Hello.
If you go to the live stream, they're going to break right now. But if you go to the live stream, you scroll down further.
That's all I can go.
See those three right down at the bottom
Oh,
there?
the secondary stream.
Secondary stream. That's the one right there.
Okay, so that was showing it.
And they just went to lunch.
Well, I'll keep that up there, so that will be a backup plan when they come back for lunch.
Yeah, that was a little bit more difficult to find.
Yeah. All right. Appreciate it, man.
No problem, buddy.
All right.
See you later.
Yep. Thanks. Okay, so it's a lunchtime. So did they say when they are returning for lunch? When did they say 30 minutes? How long is their lunch? Did you get did the judge say? Now there is some from a lot of frustration over at Florida State 247, Chris Nee, saying that this should not be continuing on when it comes to the arguments of jurisdiction. This has bled into a third day of this. It's time to wrap this up. So there is some frustration. I don't know if it's going to be an hour. I don't know if it's going to be 30 minutes. I don't know when. I'm going to tell you what, though. I'm going to leave the studio. And I would probably suggest everybody take a walk, go eat some lunch, pet the dog, say hi to your wife, say hi to your husband, go back to work. Before I do so, I want to thank everybody who has given us a super chat. Video, please, Coy. I do apologize for earlier on for not having the video up. Terry Kane, Burn, Baby, Burn. Thank you for your generosity, Terry Kane. And Gary Gold knows I did see the link. I just, I could not find that secondary stream. But we will have it as a backup as they go live here in a little bit. So what I'm going to do is I'm going to leave everything up and running. When I get back here, and I'm going to get, Greg, break is until 1:10. Okay, so we almost got an hour. I'm going to get back here before they come on live. I'm going to hopefully open up the phone lines so you can give us a call. I do got to leave this studio for just a little bit. There's something I got to get done. I couldn't get done before because a commercial popped up out of nowhere. So I will see you back in a little bit. Go take a break or comment in the comment section of how you think this is going. A lot of these arguments we have heard before. Again, got to get over this jurisdiction, motion to dismiss. A ruling has to be done today. Judge Cooper, let's get to the next part. Let's get to discovery. Let's get to something else. This has played on long enough. The arguments have been made by both sides. That's just my opinion. And I think the judge is going to rule to deny the motion to dismiss. That's what I think is going to happen. Put down what you think is going to happen. But I think he's going to deny the ACC's motion to dismiss, and it better happen today. I expect that to happen today so we can get on to something else. All right, we'll see you back here in a little bit. Stick with us, leave, come back. The live stream is not going anywhere. We're not shutting anything down. So we'll be back in a little bit. Okay, we'll be ready. Hopefully we'll be ready when they come back for lunch in still about 40 minutes from now. 40 minutes from now. The phone lines are open. 763-260-1333. Give us a call. Let us know how you think this is going. There is breaking news by Brett McMurphy. Ole Miss and USC home and home series scheduled for 2025 and 26 was mutually canceled by the schools. Both schools wanted canceled, and it happened. Not much of a surprise from USC's point of view. I would expect there is a chance that in 2026 the SEC goes to 9 games, 9 conference games. So we got that going on. The people who are in the courtroom, there seems to be a building frustration. Like Brian Murphy, WRAL. There are much smarter folks than me watching this Florida State versus ACC hearing, but I'm not sure how many of the judges' questions have anything to do with the matter at hand. This, on one sense, if this is a rush to judgment, if Florida State wants to get through all this and get a judgment in Leon County before the end of the day, where North Carolina, at the end of the road, where North Carolina, ACC getting a judgment in Mecklenburg County, both going into the venues that they want. If this is a rush to judgment, Judge Cooper, man, oh man, this has bled into the third day about jurisdiction. Make your ruling already. That's just my opinion. And I think that is a growing number of people's opinion as they watch this. Immaculate, a lot of cancellations are happening. Yep. Summary. What is the summary of today? Well, the ACC lawyers were in front of Judge Cooper, and they were saying why the venue should not be Leon County. And the Florida State lawyers, we've already heard all these arguments before. There hasn't been anything new. I believe the ACC lawyer made a mistake saying that the ACC owns all of Florida State's games, home and away, but they don't own the out of conference games. He should have been more straight on that. We've heard all this before. We've heard it all before. I'm waiting for the next shoe to drop. Like, make your ruling, and it's probably going to deny the motion to dismiss, and then what is the next step in Leon County? Thomas Coker, bench judgment in the quick hearing, maybe a summary judgment today if not reset with discovery ordered. I don't know. Again, thank you all for joining us for this PATC live stream in Leon County. Lunch, we got about 30 minutes left to go. In 30 minutes, we're going to provide the live stream as they go back into the courts. Phone lines open. Give us a call. Let me know what you're thinking. 763-260-1333. Mediation has already been ordered. They've already selected a mediator. We don't know if the sides are taking that seriously or not. What if I'm going to put out a poll here. I'm going to put out a question, poll question. Do you believe the ACC and Florida State are meeting secretly in negotiations right now? Do you believe that is happening right now? Yes? No? If they have been, I don't know anything about it. I can tell you that. What do you think, PATC community? Do you believe the ACC and Florida State are meeting secretly in negotiations? I did not take it that there were settlement talks going on. Immaculate said, we already heard in court testimony that they have had settlement talks previously. We know that there was a letter in the Florida State proceedings We know that there was a letter sent from the ACC lawyers to the Florida State lawyers, and they talked about the word settlement was in the lawyer. I had not heard that negotiations started. We know that Clemson and ACC were possibly going to start some sort of talks, but that did not go anywhere because Clemson decided to sue the ACC. The ACC was written up. I have not heard in any of these court proceedings that there actually have been negotiations that have started. Maybe they have, but I haven't heard that. Maybe I'm the only one who has not heard that, but I have not heard that actual negotiations on a settlement has begun. Giving everybody another minute to answer the question. What reason would the ACC have to speed things up? That's a great question, Steve-O. One of those possibilities, and I'm just saying it's a possibility, is the decision on ESPN whether they're going to decline, if they're going to decline to distribute ACC's content beyond 2027. Now, maybe the ACC has confidence that ESPN will not decline. And now you've got less reasons for the ACC to speed things up. Another possible motivation is just the fact that Florida State and Clemson are willing to sign over a big, massive check now. And as time goes on, that check keeps getting smaller and smaller and smaller. But your question is the question that a lot of people are asking. If those are not in the picture, if the ACC feels confident, if they feel confident in their case, maybe they don't feel confident in their case. That would be another reason just to sit down and negotiate. Thomas Coker said 180 million total. Chad Bracey, we need to probe into those media rights. D5 Terps believes the Big Ten is going to go hard after Florida State when available. They will hold at 19 if they get them, and then focus on Notre Dame and UNC. I have heard the opposite. They're going to focus on Notre Dame and UNC at 19 and see if those schools are willing to go in and settle with the ACC, and then have discussions with those two schools first. But a lot of people agree with you, D5 Terps. But late last week, we heard the opposite. Big Ten interested? Yes. In Florida State, Clemson. But maybe they're going to rush in and get some first-party talks with both those universities when a settlement is reached? Yes. But again, the big dominoes, North Carolina and Notre Dame, it sounds like the Big Ten are going to check them out before they get into the real possibility of adding on a Florida State, adding on a Clemson. We shall see. We shall see. Kerry Goldnose agrees with D5 Terps. Kerry Goldnose says North Carolina and Virginia offer 0 at football. They both suck, he says. Okay, we still got about 22 minutes left to go until this. I just hope we got to get this this jurisdiction discussion has to stop. Make a ruling. Make a ruling, Judge Cooper. Please make a ruling. The phone lines are open, 763-260-1333, 763-260-1333. Again, this is Chris Nee. 1 hour ago, Chris Nee, 247, Florida State, he says the following. Kind of mind-blowing that we are essentially on the third day of the same arguments and comments. Mind-blowing that we are on the third day. Let's get this wrapped up. That's my take on it. What is your take on it? Judge Cooper, I'm hoping he comes back after lunch and says, okay, motion to dismiss is denied, and this is what we got to do to schedule discovery. Something like that. Thomas Coker said he's already decided on the other issues, so this goes and then quick to judgment. I can't imagine Florida State and Clemson would go through this without having a landing place already in place. And I will answer Matt O this question. It is impossible, absolutely 100% impossible to imagine the Big Ten and the SEC's legal departments giving their commissioner the go-ahead to have discussions, first-party talks with Florida State and Clemson. They might have a pretty good idea, but nothing is for certain.
Call from.
I did not get the name.
BJ.
BJ, thanks for calling in, BJ. The floor is yours.
Hey, what's up, Greg? As always, thanks for having me on. As it pertains to the FSU ACC stuff, I think two things are going on. I think it's been relatively quiet, with no sides and no, real motions before this last week. I do think they're in negotiations, they were forced to kind of do arbitration by Judge Cooper. That we don't officially know has that started or what phase they're in terms of that. But what I think with Judge Cooper, so I was born and raised in Florida, and so Florida courts are a little different from a lot of other places. And especially when it comes to appellate stuff, it doesn't go to the state. Every district has its own appellate judge or appellate circuit. And what Florida likes to do is they like to give both sides, empty out all your guns. Because when it goes to appellate court, they want to be almost like appeal proof. Whereas most other courts, I live here in Colorado now, most other courts, that's not the case. You say your piece, you have a defined period to speak, and once that's over, you can bring up new things in the appellate process. But in Florida, you can't. It doesn't make it better, make it worse, but it hopefully gives folks some perspective on how Florida justice system works. It's quite different from a lot of other justice systems, in my opinion.
Mm-hmm.
but I missed a lot of this morning. If you don't mind, like, was there anything of note that should be brought up?
Not really.
I gotcha.
During this morning, not really. There was a little bit of I think the ACC lawyer got a couple details wrong and everything, but nothing of importance.
Gotcha. I got another question for you too. I'm watching the College World Series, and this is more of just it's not really a legal question, but how do you think Jim Phillips and the ACC 6, right, the Wake Forest, the Boston Colleges, the that Jim Phillips relied on to bring this suit up against Florida State, how do you think they feel when they see like Florida State just kicking ass and taking names athletically while representing the ACC logo? Do you think it makes them feel any kind of way?
I don't quite get what you're asking.
So if there is a legal battle, right?
Yep.
Florida State, is anti-ACC, supposedly, right?
Yeah.
But they're representing the ACC. They did in football by winning the ACC championship.
Yeah.
They performed well. They performed well in the ACC tournament. They performed well in the College World Series tournament. To me, I will feel kind of odd if I don't want this team in the conference, or me and this team is going back and forth in the conference, but they are consistently winning and representing the ACC.
Well, they want Florida State to be a member of the conference. I still don't understand. I'm sorry, BJ. The other ACC schools want Florida State to remain a member of the conference, right? They all Florida State's trying to get out, and they don't want them to leave. So I don't quite know what you're getting at.
I mean, if I wanted somebody to stay, I wouldn't sue them.
Well,
I would have conversations.
No, that's not big. You can't. So you're saying they shouldn't sue Florida State, and Florida State should just walk out the door?
I'm saying they should.
Those other universities signing the Gore, they couldn't possibly do that. That was not even an option.
I think before it got to this point, Greg, there was, for the last 2 years, Florida State at the ACC meetings have been brought up, hey, we need to change this tiered structure. Or we need to change this revenue structure.
Yeah,
Okay. And they voted, the teams voted no, resounding like a no. The only three teams that voted for a change in structure was North Carolina, Clemson, and Florida State. So if you wanted this team to stay, that should have been, the negotiation at the meeting should have been more of a play than let's sue them. That's all I'm saying. So if I'm looking at it, I'm biasly, if I really want to get a resolution by this team, I know that's a top tier team in my division or in my conference, let's try to come to a settlement to make this work.
Yeah.
And the ACC team decided to sue.
Yeah. Well, okay.
That's all I'm saying.
Okay. So, they did do an unequal revenue sharing. They did get that bill. They did get that plan passed. What they did not include was the viewership. I mean, you can't.
Correct.
So if you look at it from Duke and Boston College and Syracuse and all these other perspectives, I mean, it gets to the point where you're making such a... You've got to look out for yourself, too. I mean, they're trying... The ACC, they're trying to get as much money out of Florida State as possible. Florida State's trying to get out of here least money as possible.
Correct.
I don't... But if these schools had their choice, they would want Florida State to stay. There's only so much they can do with the unequal revenue. That was not a solution to anything. So I don't know what, I don't understand what Wake Forest is supposed to do. Of course, they're going to want to support the commissioner in making sure that the ACC gets the best deal possible out of Florida State and Clemson. And Florida State's looking out for their interests, and Clemson's looking out for their interests.
I would say, Greg, I agree with you.
Yeah.
In principle. However, I think you, as a leader of a university, let's say Wake Forest, Boston College, I have to know what it is and what it's not. So, if I'm making $44,000, the equal revenue sharing, let's say I go down to 35, I lose $10 million off the top. That's hypothetically.
Yeah.
If I lose $10 million, $35 million is going to be better than your situation with Clemson, North Carolina, and Florida State, not in your conference. I'll be hard pressed to see ESPN giving the ACC without those three teams $35 million a year without those teams. So I'm not saying it's right or it's wrong, but if those three teams leave, Josh Pate, he was cryptically speaking or posting about the ACC doing the opposite of expanding, right? So, I like, how would the ACC look without those teams financially? I don't think they're going to get $35 million.
No.
So, in my opinion, $35 million a year is better than $25 million a year. That's all.
Yeah.
No.
Yeah. Yeah.
Thank you, Greg, as always, for having me on.
Appreciate it. Thank you, sir. Thank you, BJ. Appreciate it. BJ's correct. BJ's correct. It's just, they did the unequal revenue sharing. These schools are not going to just lay down and say, okay, we'll take 20 and Florida State takes 60. It gets to the point where, and they're going to try to get as much out of Florida State as possible. And I'm not sure, that's basically it. Now, if Clemson has a really good day on July 12th, and if the judge passes a summary motion, a summary judgment on the first cause of the amended complaint by Clemson, if the judge rules that Clemson can leave the conference without, once they leave the conference, they get to bring their media rights with them. Then the ACC, we're going to be saying the ACC should have settled for just about anything with Florida State Clemson. Both sides are risking something here. A settlement could happen. It could happen today. It could happen next week. Now, again, people are commenting to me, Greg, again, they know exactly where they're going, Clemson and Florida State. They might have we know they've got some evaluations, third-party talks. We know that people who will hold interest from Big Ten have talked to people who will hold interest from Florida State and Clemson, but there hasn't been first-party talks. And you know what? It's okay for people in the chat and people PATC community saying Florida State knows exactly where they're going. I'm okay with that, but I can't say that. I can't say that unless I know that. And quite frankly, everybody, I've been told the opposite. There is no done deal. There hasn't been first party talks. There's been no offer. I have to be accurate as best as I possibly can. I've got to be clear. You can see how Florida State and the Big Ten, how that would be beneficial for the Big Ten and for the Florida State. But they haven't had first party talks. They just haven't. Unless the only way that the Big Ten has had first party talks with Florida State, if there has been a secret settlement a month ago, and now they have talked. Let me put it to you this way. Let me ask you a question. We know because we know our brand and our worth. Kerry Gold knows. Thank you for the super chat. But that's different. That's different. Knowing that Florida State would have a spot in the Power 2, that's a different question. But when people are saying they know exactly where Florida State is going, I'm telling you, they don't. They might have a good idea. But they don't. Let me ask,
Call from
Bobby.
Bobby, can you hold on for a moment?
Of course.
I'm going to ask everybody this question. The question on Florida State exactly know where they're going, how much they're going to get paid. They've gotten an offer. Everybody who believes all of that. Let me ask you a question. Do you believe that Florida State has been truthful in their pleadings to the court? Do you believe Clemson has been truthful in their pleadings to the court? If you say yes, then you've got to walk away from what you just said, from what you've just believed. Because Florida State and Clemson have both have said they have not been able to have meaningful conversations with other conferences and media partners. They both have said they would like to be able to talk with other people. They would like to know what their value. Florida State says it has hurt them that they have not been able to talk. Clemson says it has hurt them. In fact, Clemson has sued for damages because they're not able to have talks. Do you know why they're not able to have talks with the Big Ten and the SEC? Because the Big Ten and the SEC legal counsels won't let them. They won't let them. They're not going to let these schools. The legal counsel of the Big Ten is not going to let Tony Petitti have talks with Florida State until he, right now, currently, no matter how stupid you think it is, no matter how foolish you think it is, that grant of rights right now goes to 2036. The contract, if ESPN doesn't decline it, goes down to 2036. So you can't have it both ways. You can't say Florida State and Clemson knows exactly what's going to happen once the settlement is reached. It's all done, Greg. It's all sealed and done. Oh, yeah, Greg, Florida State and Clemson have been 100% truthful in their pleadings to the court. You can't have them both. It can't go both ways. You can't have both of those because they run against each other. So I'm telling you this, PATC, we're telling you, and you can take it however you want it, but you got to be consistent. Florida State and Clemson have been 100% truthful in their pleadings. They're unable to have their first-party talks. And if you're not having first-party talks, if the Big Ten is not telling Florida State, you got to build yourself a $10 million multimedia department. Clemson, you've got to hire 150 new faculty members for research. If you're not having those first-party talks, you don't know 100% sure where you are going. I'm telling you the truth. I am telling you, it is my job to tell you maybe what you don't want to hear. The question of Florida State being of great value. Yes, football value. Yes, when they play a football game, they bring money into their immediate partners in the conference. Yes, 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 yes. But the question of, Greg, I can't tell you 100% sure. I can speculate. But there is a big, strong reason why you can't put it in pen. Florida State does not have an offer. They don't have an offer. It is absolutely 100% impossible that Florida State has an offer on June 18th. It just is. And I'm telling you the truth. If you want to come here and listen to the truth, come here and listen to the truth. When I tell you I don't know what's going to happen, I don't know what's going to happen. Florida State doesn't know either. They're feeling good. They're feeling really good, but they want to have meaningful talks with the Big Ten and the SEC. Bobby, go ahead. The floor is yours.
Well, and I will back you up, Greg, if you don't mind. And there's a reason why the Big Ten and SEC lawyers are very, very, very skittish about this.
Yeah.
Because if they get sued for tampering and you take one of these schools, they can sue you for all of the future revenue you're going to make with that schools because of tampering, and that's not worth millions, it's worth potentially billions of dollars. And they don't, that's why, and they could sue the network for tampering if they were doing it on your behalf. That's why all these lawyers are freakishly careful. Sure, there's third-party talks going on and those kinds of things, but yeah, they have to be extraordinarily careful because that's the end result. If you get caught tampering, you can't touch that school with a 10-foot pole afterwards.
Yep.
You just can't.
Yep. It's in, and again, Bobby, you can't have it both ways. You cannot profess to believe that Florida State and Clemson have been honest in their pleadings and then go back and say, well, Florida State knows exactly what's going to happen. No, they don't.
Yeah.
You can't have it both ways.
No. That goes to what you did in your theater the other day, where Florida State got this other offer that you kind of put in very mysterious terms. And
that wasn't
I don't know
by
if
conference. That was
what's that? No, it wasn't from a conference.
Yeah.
No, I mean, I have my own interpretation of that. When you talked about the receipt, I kind of thought that could be you had an E on your receipt. That could be ESPN putting a big offer up there of some kind, with staying in the ACC or whatever it is. And the key could be the key of getting out of the ACC very easily, not a key to the box, a key to getting out of the ACC. I mean, that's why I say they're getting third-party talks. They can get a sense of what and you can get a sense of what the offers are going to be if you're Florida State or Clemson.
Yeah.
Just look what the other teams are getting.
Yeah. Yeah.
This isn't rocket science.
Yeah.
We know.
BC Knoll, they do not have an offer, but they're highly confident in their landing spot.
Sure, and they can tell whether when you have third party talks whether they're getting positive feedback or not. They can tell.
Yeah, but I have to be precise because this is not my first rodeo.
No,
they have not had first party talks. They have
they have first or second.
There's a lot to discuss, but Florida State is very valuable. Absolutely.
Yeah.
But go ahead. Sorry, Bobby.
No, you're fine. No, they haven't had first or second party talks. Yeah. I mean, they have to be very careful. Look what the Big Ten did with Oregon and Washington, who wanted to come.
Yeah.
How slow they were.
They did have first party talks.
They did. They did when USC and USC. And even with the teams that they could have first party talks with and wanted to come because they didn't want to get accused of blowing up the conference, they were slow with. Think about that.
They couldn't do it. The legal counsel won't do it. Yeah, I'll go into it again at some other live show, but during the USC, when the USC called the Big Ten and all that was breaking, and we were breaking it here at Peek Around the Corner, it was Kevin Warren's legal counsel, his right-hand man, who followed me 9 different times on X. Back then it was Twitter. We documented it all. We had people snapshotting it. We've got other documents. The legal counsels give these commissioners the go-ahead to do this, that. The commissioners are always checking in with their legal department. And there is zero chance that PTD or his right-hand man has met with Florida State. Florida State understands their value. It is big. But there are a lot of people out there, a lot of people. You want to, I'm not going to show you my direct messages because it's confidential, but I've got a whole bunch of Florida State insiders telling me they've met, it's a done deal, they're going to get a full payout. Greg, you don't know what you're talking about. It's not my first rodeo. Florida State could become a Big Ten member in another couple months, but they have not had first-party talks. The Big Ten would not do that. Phillips, this is 100% true. 100% true. In fact, I'll find a report, but Phillips reminded the commissioners at a recent meeting, do not talk conference affiliations with my members in our conference. So the commissioner said, no, we would not do that. So it just hasn't happened at that point. But go ahead, sir.
And just to back you up again, it's
hopefully soon here. Go ahead.
It's not just the conference commissioners. It's also these Big Ten presidents sit with their lawyers as well.
Yes, yeah.
I'm very interested in what the water glass, the Tyrannosaurus Rex little message meant.
Yeah.
And my first knee-jerk reaction was Notre Dame, considering the other messages about Notre Dame's got to move first, but I'm starting to think it might be ESPN is putting out signals that they're starting to let the other members know or the conference know they're not going to renew past 2027. Why? Why would ESPN do that? They want some of these members in the SEC, and to get North Carolina free right now, what's the easiest path? What's the easiest path? Is it to let it go through North Carolina's government and in a process we don't even know how it will play out because it's never been done this way before? Or is it to just say we're not renewing?
Oh.
Which is easier.
Yeah.
If you're ESPN. I can tell you which one I think is easier.
Renew.
Yeah, and then instantly all those schools have to go into negotiation. It doesn't matter they have to. They have to start looking past 2027, and you're not hurting anybody. I just wonder if that wasn't what he's starting to hear in the background, is that ESPN is leaning that way or thinking about it. I've heard rumors about ESPN trying to, again, renegotiate the deal as it is, to try and free these members up. The ESPN and Fox and the Big Ten and the SEC, they want these members to be free. And they want them obviously free sooner rather than later. I think that's obvious. And the one, besides some of the smaller members of the ACC, the one organization that does not want them to be free and wants to drag this out is the ACC. And the ACC is really in a pickle because their main media partner is kind of on the opposite side of this. And that puts them in a pickle. Because the Wayne Pearson who might back them up is also looking to poach them. And especially if they find that it's getting closer and closer to maybe taking this media deal and making it public. And so now they're in a pickle twice. And also I would say with Judge Cooper today, he's being careful. He's being very careful.
Yeah.
And he has to be because he knows ESPN is going to appeal this.
Yeah.
You think he's going slow? Yes, he is. And he's purposely throwing all of the opposing arguments at each of these lawyers so that when he comes out with his ruling, he's been slow, he's been methodical. I think everybody would say, yes, he's been slow and methodical. Well, yeah, there's a reason for that. And if you remember his last ruling, how many cases he cited and how methodical he was. Exactly. Exactly. That's why. Yeah, that's why this isn't soap opera TV.
Yeah. I'm just getting a little frustrated though. I wanted to move on, but you're exactly right. He's trying to protect from the appeal process and everything else. Yep.
Yeah, he knows this is going to get appealed. He knows it. And so he is purposely going slow, and he's being methodical, and he wants them to chance to respond to whatever counter arguments he can make, and he'll put out his ruling, and it will get appealed. But the more methodical he can be, and the more things he can cite, the less likely that the appeal is going to be successful. And that's what he's doing. And so, yeah, I know everybody wants it to go faster. But this is what happens when you get lawyers involved. They make sure they get billed by the hour.
All righty, Sir Bobby. I appreciate the call. We've got something.
There you go, Greg. That's just my two. Oh, and the only thing I would say is you made mention the other day of sliding an envelope to referees who were refereeing a Wisconsin game to get them to against the Evil Badgers. And Greg, I have to tell you, your $6 for 7 refs in that envelope will not do much to get the refs to side against Wisconsin. I'm just saying.
I know. I'm too poor to have any impact. I understand.
That's right.
All right.
Thanks, Greg.
Thank you, Bobby. Appreciate it. Great call.
Yep.
All right. Great call by Bobby. It looks like we're getting close. Kerry Gold Nose, Greg, who wouldn't want a top 8 all-time blue blood university like Florida State? All I've been saying is Florida State wouldn't be doing this without a landing spot confirmed in third-party talks. And I will restate, thank you for the super chat once again. Thank you so much for your generosity, your friendship, Kerry Gold Nose. I would again, because I'm just going to say it. A landing spot cannot be confirmed by third-party talks. A third-party talks is, for an example, somebody who used to be an athletic director at Indiana, now talking to somebody representing the interest of Florida State. So that Indiana former, again, this is just an example, talking with Florida State, saying, the landscape at the Big Ten, you're a candidates list, and you're looking good here, and all those talks, those are third-party talks. But the decision makers, all the interests combined, that is first-party talks. None of that has happened. So you cannot confirm a spot with third-party. I'm not trying to rain in anybody's parade. I got to be honest with you, though. Florida State feels good about themselves. So does Clemson. We've been talking about that forever. They have reasons to feel good about themselves. But they don't have a confirmed landing spot. They have a pretty good idea. Florida State would want to have meetings with both the SEC and the Big Ten. Why close their door? Why try to create a bidding war once you are able to have meaningful conversations? I go back to Florida State's own words. They have not been able to have those talks. They just haven't. Neither have Clemson. It doesn't mean anything against Florida State and Clemson. I think people are, oh my goodness, that's the shot against Florida State. No, it's the legal It's how things are done. And then one other thing. Yes. You don't make a decision until the moment you need to have to make a decision. Fox, CBS, NBC, Big Ten, SEC, ESPN side of things. You don't make a decision until you need to make a decision because you don't know what's going to happen in the world. Could have a world war, could have a depression, whatever. So you don't make the commitment until the time, all of them. USC and the Big Ten talks went on for a couple months, and then it got real serious in May. And then in June, and then it was decision time, yes or no. Washington and Oregon had first party talks with the Big Ten and Washington, D.C. and New York City, and then months passed. They were waiting to see if the Pac-12 was going to get cracked again. They were cracked again. These talks, August 3rd into the morning of August 4th, bam. So nobody is making any definitive, like, we are going here, we are taking you on June 18th, when you don't even know when Florida State's going to get out of the ACC. It just isn't happening. That process is not happening. Florida State has every reason in the world to feel good about themselves. And I have every reason in the world to be honest with you. That's all I'm saying. I'm going to let the other people rush out and say, this is definitely happening, or this school is going to make this much money in this conference, and it's happening in 2025. I'm not going to do that. I have worked too hard, too long. I've talked to too many people. I've established too many relationships, including you all. I'm not going to give you a line of BS. Not going to do it. Not on this show. Florida State have every reason to feel good. That's why we're covering this court case. That's why we're covering all this stuff. But I cannot look at you in the camera and say, oh yeah, it's all been settled on. Yep, it's all been settled on. No, it hasn't. No, it hasn't. Okay, thank you, Carrie Goldnose, for your, once again, incredible generosity to our program. Thank you so very much. Let's see if we have any action going on here. What do we have? What do we have? We do have something. Holy smokes.
Other case that the Attorney General has filed, I'm assuming, is it against ESPN only?
Technically, I think it's only against the ACC.
Yeah.
No, I'd rather have you address it.
Sure.
It was filed against the ACC, Your Honor. It's a strictly Public Records Act case. ESPN has moved to join as a party.
Okay.
Obviously, it involves ESPN's confidential information.
All right. So there's the other case that's in circuit court, and I think Judge Dempsey has been assigned that case. I do not know the status of that case. I'm trying to purposefully not over-involve myself as far as knowledge of other cases unless absolutely essential. I know the case exists, and that it's we call it a Chapter 119, which is a public records case. So is that a factor, Mr. Rush, in these I'm going to call them sub-prongs? Let me see. I'm looking again at Louis Vuitton. Proper considerations. This is under the fair play and substantial justice prong, and Louis Vuitton, I think, if I've got this right, has says under that prong. let me see. They, one of the arguments I've seen in the 11th Circuit case is that under the fair play and substantial justice prong, as it would apply here, is it assuming FSU establishes that ACC availed itself of Florida's benefits and that its claims relate to contacts or a contract between ACC and Florida or Miami, does the ACC make a compelling case that the exercise of jurisdiction in Florida violate traditional notions of fair play and substantial justice to avoid jurisdiction? That case, just for the record, is Diamond Crystal Brands versus Food Movers, 593 Fed 3rd, 1249, 11th Circuit, 2010. And let me finish this, and then Louis Vuitton at page 1358 says that proper considerations under this prong, there are multi-prongs under this fair play and substantial justice issue. They say proper considerations are the defendant's burden. I think that relates to what I just read, burden to show that exercise of jurisdiction would violate traditional notice of fair play. And 2, Florida's interest in adjudicating the dispute and plaintiff's interest in convenient and effective relief. And 4, the court's interest in resolving the issue. So that sounds like a lot of prongs, so those are the only ones I'm going to give to you. Just ask if you can, in general, comment on what I'm going to call the fair play and substantial justice issue as it relates to minimum contacts or the federal due process issue.
Yes, Your Honor. In over and above what we've already talked about, being that it is Florida property, it is Florida content, it is Florida media rights, it is Florida constitutional law, that it may be Florida may be the only place on earth that this matter can get litigated. And given the discussion with lack of diversity of citizenship, it may be the only place in the world you can resolve this. And it needs to be resolved, Your Honor. So that puts
Well, I would hope that you all would resolve it at mediation, but I read somewhere that maybe I think maybe ACC objects to my mediation order because they haven't answered yet. No, you don't? No. I thought I read that somewhere that I jumped the gun on mediation. I don't take offense at it. Okay, I don't take offense at it because I just am as you know, I believe let me restate again in case there's any concern with my mediation order. I know I'm kind of diverging, but I think both sides know each other's case pretty well already. I think both sides feel they have a pretty good handle on the law of the issues, whether it be from Florida, North Carolina, or federal law. Whether it's these lawyers have always been involved. I know the parties have been involved in each other on these issues for some years, and that's why I think it's not premature to order mediation, whereas in a case normally as complex as this, it might be before discovery. As I told you before, I participated in a lot of mediations as a mediator and as a lawyer, and I do think the parties know each other's positions probably better than in most cases at this stage. And when you get into mediation, if you feel that there's something that needs to be done, there's nothing that says you can't suspend a mediation and do some discovery or do some other process that you might agree to. So that's my thinking, in that I know there's been no discovery. I know there's not been an answer, but we've been here, this is day 3, on pretty detailed
Come on, Judge,
legal
get on with
discussions
it.
that also have the factual assertions from the two sides weaved into the legal discussions. So I believe the two sides know a lot about the case. And having mediated cases, you don't have to wait till like the week before a trial to be properly prepared to mediate a case. And there is a fiscal benefit to mediating an extraordinarily complicated case early. And I'm not trying to deny anybody any work or anything like that.
Especially lawyers.
Lawyers.
Yeah.
And I know these lawyers on both sides are very good and they have all the work they can handle. But there's a certain amount of cost savings that would be beneficial to both parties if there's a way to resolve a case. Now, I'm not naive, even though some people might think I am. I know there is a possibility you might not settle, but sometimes mediations start a process that can ultimately lead to a settlement. And I've done this a very long time. And the first time I probably told you this, but the first time I was ordered to mediation, I thought the judge was losing it because I thought there was no way the case would ever settle. And as I'm sure you probably figured out, it did settle. So, and I'm still almost, at least on a weekly or monthly basis, I have lawyers who come up to me who say, Judge, you know what, we settled that case. Just had it recently where we went through a non-jury trial, and we had closing arguments, and we had back and forth on some legal issues, and I didn't give rulings, but I gave some issues that I wanted the lawyers to further brief. And I think that process allowed them to talk again, and they worked it out. So how cases get settled, we kind of know, but it's so different that we don't really totally understand the process. It's a uniquely human process in that it's emotions, it's rationality, sometimes it's irrationality, it's cost-benefit analysis, it's public relations analysis with public institutions like we have here. There are lots of issues. I've also found when there are even emotional issues are in every case. But the more people get up in court or in writing, say something negative about the other side, that much harder to settle that case. And so everybody's doing their job, and I'm not being critical of anyone. I'm just saying sometimes early is a lot better than late. So,
Your Honor, I couldn't agree with you more. My first advice to all my clients is litigation is no way to resolve a dispute. And I've been doing it for 40 years. So I couldn't agree with that more. It should always settle. I would say there are a couple impediments that I would want to bring to the court's attention. My client doesn't have the ESPN agreement. And without the ESPN agreement, without the mediator having a copy of the ESPN agreement, I really don't know how far we can get. I'm actually reluctant, candidly, to recommend that my client enter a mediation about an ESPN agreement that it doesn't have. But we are trying to work that out. I'm not trying to cast any blame.
There might be ways to work it out.
There may be ways to work it out. And secondly, and I just speculate on this, Your Honor, I can't speak to it, but we are an entity, we are a public university. The other side of this is a voluntary association made up of like a homeowners association. I don't mean to denigrate it, but
no.
It basically has a bunch of people who are far from the fire. They're far from the shrapnel. They're far from the front line. So getting them to appreciate what kind of risks there are in the abstract
I found in my career to be a particularly difficulty, that there's danger out there and there's a reason you ought to settle.
I agree with you. Here's what I would say. I represented a lot of private entities. I represented a lot of
What are we
entities.
doing?
I've been to more than my share of shade meetings, which are,
for
those who don't know, are authorized.
We've already had these
meetings that aren't
conversations on
automatically
mediation
public,
settlement.
so
If
the
they're going
attorney
to do
and
it,
the
they're going to
public
do it. It
entity
ain't going to
can
happen
discuss
because Judge
settlement
Cooper is
issues.
pleading them to do it. Get on
And
with
that's
the
authorized by
case.
statute in Florida. So there are those issues, and there are also issues from both sides. No one never really knows if some other person's going to join the arguments made by FSU and Clemson, or whether someone's going to change those mind about arguments. No one knows. And things could happen to make one side's case a lot better or a lot worse. And my experience as a lawyer was when I got close to trial, the more I really focused it on my case, it either got a lot better or a lot worse. It never stayed the same. And mediation sort of forces you into that analysis a little early. Does it mean, I know the ESPN agreement is an issue. I don't know whether it will be resolved or not. I don't know whether it will be this court or in another court. I'm not making any predictions on that, but it has to start sometime.
We've been working on an interim protective order that we hope to be able to submit to you in a few days.
Okay.
We're down to a few tweaks because we've always taken the position they're entitled to the agreement. We just want to be very protective of the social.
I understand.
They've been very good at cooperating.
Until this court or some other court passes on that question.
Right. And there are also people that have interest in public records issues than just the parties, as I'm sure you know.
And that's Judge Fenton's role.
Yes, and the press has interest in it. The Attorney General has interest in it. Multiple other people, they don't even have to be in the press. They don't have to be an official to have an interest. So it's Chapter 119 issues, again, are, I don't know if they're somewhat unique in Florida, and I don't know in other states. I'm sure there are other states that have variations on that, but each state has a little bit different focus on it. I think I know what Florida's focus is on it, but I don't ever try to anticipate what anyone might do.
Okay.
But I do know
the
and
judge
I'm not
started
sure
out by
Justice Lawson wasn't on
saying,
the
we've
court
got to
when they
speed this along.
last wrote
We've got to
and
speed
encouraged
this along.
mediation in every case.
We've spent
Or
90%
were
of the
you an
time
alumni by
after
that time?
lunch talking about mediation settlement when it ain't going to happen right
Yeah.
now. It ain't going to
And
happen
I agree.
because this
I
judge
agree
is
with the
saying
court.
it. We're wasting
in
everybody's
mediation.
time.
It
I'm
was a
about to go on a
COVID,
rant. Let's go, Judge. Come
order
on.
about ensuring mediation in every case, with the exception of one or two unique type of cases. But I agree. I think I agree with that. And it used to be the local practice here was you enter an order requiring mediation 45 days before trial. And I'm not criticizing anyone who does that now. I just personally think that's way too late.
Well, and I can assure the court, we've had, at least speak for myself, we've had very productive discussions, not only about the mediator, but the shape of the table, so to speak, so that we can comply with the honors.
So you were around in 1969 or 70?
I was very young.
1949.
I was a teenager.
All right. I was in speech class at FSU, as I'm sure you know.
Who
That's where I
cares?
went. And I'm pretty sure I was assigned to give a speech about the shape of the negotiating table for the Vietnam War.
The shape of the
negotiations.
negotiation table.
That was, I don't have a copy of it if you're looking, and I'm sure no one does, but it was obscure.
And I think I can assure the court, we've all been working collaboratively to meet the spirit.
And I would agree. My concern and speculation is how much leeway Mr. Cooney can have, given that he answers to 18 voices.
Oh,
that
I
makes it
understand.
hard for him.
Well, he has to answer not only to other people in the conference, there's also ESPN who has an interest in it too, and I'm assuming, like you say, it's filed a motion to intervene in Judge Dempsey's case.
Oh, God.
So,
I've seen Mr. Rush before too. He's got a lot of strong personalities on that board. So
We've got them unified, Judge, just one unit, singing the same song.
we each have our
I know, but talking is good. It doesn't mean that you can't go on parallel tracks. You can talk on this track and you can litigate really hard on this track. And lawyers understand that. Non-lawyers don't always.
You are
understand
correct,
that, but
the
you can
architect.
do that.
It's gone
So,
pear-shaped.
you may proceed.
And I'm going to try to wrap it up, but
Okay.
actually, this is a fabulous kind of dovetail of all these concepts. So the question is, where should this be litigated? And there's a lot of this in that statement. But one of the things is exactly what we just talked about, the confidentiality of the ESPN agreement. And I'm not talking out of school, that confidentiality provision says, with respect to this case and with respect to Florida State and Miami, it must be determined under Florida law. So it is only Florida law that will decide in these courts and in this dispute, even if it's in North Carolina, how the ESPN agreement is handled. So that ties all those concepts in together, which is whatever court ends up with this prize, it has to apply Florida law, the public records law, to decide how the ESPN agreement must be treated. And that would be kind of game, set, and match for me with regard to the analysis you just described. And then finally, Your Honor, 2/14 of all the home media content produced by the ACC, which is 14.3%.
It's 2/14, 1/7?
Correct.
Okay.
Miami and Florida State.
14%, 14.3% of all the media content that the ACC sells is made in Florida. They've not cited to you a case that says 14% of someone's business is de minimis and does not make them at home. The Woods case established that 18% is more than enough for the access of general jurisdiction. And that case didn't have the Fanatics, didn't have the bowl games, didn't have the conference media meeting. But I ask you, where is their Florida case that says 14%, 14.3 does not subject a defendant to general jurisdiction? And that's my finish, Your Honor, unless you have questions.
No, thank you.
Thank you.
Counsel, can you wrap up in about 15 minutes?
Would you just give me 2 minutes to just?
Sure. I'm just going to step outside and stretch my legs. Y'all can do that too. Court reporter, are you okay? You need a break or anything? Okay. I'm just doing this so I won't overhear anything.
I don't know what to say. That was other than there was a couple points the Florida State lawyer made. One is, look, you talk about mediation, you talk about settlement. the lawyers here in this case, they don't have the power to settle. They don't have when you talk about mediation in the Leon County courtroom or outside the courtroom, there's a whole lot of different parties on the ACC side of the coin. There's ESPN, there's all the schools. So, and we've said this before, the negotiation table, if the ACC and Florida State are actually meeting or are going to meet here shortly, it's not having to do with this court. That is my opinion on it. And I don't know, was there anything else worthwhile that was said during that since we've gone from lunch? That was all time completely wasted, in my opinion. So, anyways, we are waiting for, I don't know what we're waiting for anymore. I've lost the plot. I've absolutely lost the plot. We are trying to, the pleadings today is about venue, about jurisdiction. Let's get to a ruling. You've heard all the arguments, general, specific, all this stuff. The salami. We're done with it all. Get to a ruling. If you wanna dismiss this out of the state of Florida, then do so. If you're gonna reject the motion to dismiss, which I think you're going to, then do so. This is the third day of this. Let's go. My goodness. This is like watching the Minnesota Golden Gophers and the Iowa Hawkeyes offense. It's ridiculous. Let's go. I don't even know, 10 to 15 minute break. This is just... If you're new to the channel, or if you haven't done so yet, please subscribe to our channel. Open up your notifications. We could come on live again later tonight as they're still proceeding. They're still talking about the jurisdiction, the venue of this case. Smash the like button if you like this content. Rock and Ran on the bright side, Greg. This judge is ad revenue and premium subscription. I don't care about that. Come on, let's get to a ruling for God. This is Expedition. I don't care that it's gone this long. Expedition Greg. This show has gone from breakfast, lunch, and dinner. I'm fine with that. Is we haven't gotten anywhere. This was supposed to last an hour. 30 minutes ACC, 30 minutes Florida State on the subject of jurisdiction. We've been at this for 5 hours and we're still on this. And this is the third day of this. Come on, let's be blunt. This is ridiculous. This is turning into some circus. Just rule. I don't even care anymore. We've lost the plot, ladies and gentlemen. Holy smokes. Can you imagine Discovery? This thing could be going on. They're still on the initial motion. The U.S. Supreme Court rules faster than this. The ACC is completely stubborn. Well, I would be stubborn if I knew the. Are we back live here? What's going on? No, we're not. We're hearing some murmuring. Unbelievable. Am I overreacting?
Well, you know, he might have
And then, we got to change rooms. Computers don't work ever. They never work. It's almost like Greg Flugar is running their IT department. Nothing works. That, since we've come back from lunch, it's been complete nonsense, basically. The rush to judgment. Florida State is banking on the fact that here at their home field advantage in Leon County that they can go through all these processes and appeals before ACC can get through their processes and appeals in Mecklenburg County. Florida State is hoping that this goes a little bit quicker than what we're seeing. The third day of this. Woo! Great question. Great question. Great question. Great question. Hold on, everybody. Hold on.
Call from
Where is the DM?
Can you hold on for a second, sir?
Sure.
I do appreciate it. Crab cakes in football. I'm sick as a dog, and this isn't helping. I'm sorry about that, crab cakes in football. I hope you start feeling better. Thank you for your super chat. I do appreciate it. Mark Bowman, when will the details of the ESPN agreement be made public? Well, that is one of the motions that Florida State has filed, especially when it comes to Attorney General Moody. We don't know. We can't quite get to that. There hasn't been a ruling on it, of course. There really hasn't even been a hearing on it from both sides in Leon County. Thank you for the super chat. Hopefully someday we'll get to that part of the argument. Ryan Willie, the Evil Badger. Lawyers like to hear themselves talk. Thank you, Evil Badger, Ryan Willie. Thank you, Mark Bowman. Crab Cakes in Football. Kerry Golden Nose, Terry Kane, Coy, Kenneth Klager, Donnie McNerney, and Michael Monk for all your donations. Caller, go ahead. Let it rip. The floor is yours.
Hey, Greg, it's Larry.
Larry, thanks, sir.
While we got this recess, there's been an aspect of this I've wanted to talk to you about, and that's settlement. Like, what is the ACC process for settlement? Because I think the different universities in the conference have different different goals in a settlement.
Yeah.
And I guess maybe Miami is probably the best school to talk about. Does Miami actually want a high settlement number, or do they want a low settlement number?
Exactly. We don't know what their process is. It's like herding cats. They all have different motives. They all have different set of lawyers.
That's the word I'm looking for, Craig. That's the word. Motives. Because like if the ACC lawyers and the Florida State lawyers come together, and let's just be ridiculous. Let's say they agree on a $350 million settlement.
Yeah.
Miami's going to vote against that. North Carolina State and North Carolina State are going to vote against that.
Yeah.
Because it's too high, which is an insane. Wait a minute. No, we're not being fair enough with Florida State. Let's lower the number.
Yeah. Oh, yeah. There's going to be cloak and dagger. There's going to be horse trading votes. There could be the possibility of all that stuff. You're absolutely right. That number, how it gets settled on, and then, of course, you throw in the element of ESPN, along with the interest of Wake Forest and Duke and North Carolina State, in which all their interest is different. That, again, if this If the negotiations are,
Court back in session. Okay, everybody have a seat.
if negotiations are happening,
Okay.
I'm getting
Ready to go?
voices here.
Your Honor, I appreciate
for
the
what, Greg? That's the question.
time. I hope to focus it a little bit.
I'm going to
I know
have to
that we
let you
are
go. We're back
a
in
little
the
bit,
court.
pressed for time.
Great
but
call. Excellent call.
Yeah,
Fantastic.
so much for my hour analysis, right?
Well, hope springs eternal.
Yeah.
Great call.
Your Honor, I wanted to get back to what the plaintiff alleges in its Second Amendment complaint, what this case is all about. It's about asking this court to construe two provisions in two separate contracts. One is a provision in the grant of rights agreement about whether or not FSU receives back its media rights if it withdraws from the conference. And second, it's about construing a provision in the ACC's constitution about whether or not the withdrawal fee is a penalty. And the reason I raise that is because it gets to the entire related to point that is at issue in specific jurisdiction, both under the Florida long-arm statute and under prongs of the due process minimum contacts analysis. And when we remember what this case is about, it's not about operation of bowl games. It's not about de minimis sales at Fanatics in Jacksonville, particularly since there's no evidence that any of those sales are in Florida or not in Florida. It's not about most of the issues that the FSU is asking this court to look at. And so FSU has to tie its allegations relating to specific jurisdiction to a particular cause of action. And when we look at what the relief they're
We've already
seeking,
talked.
those items that they are focusing on do not relate to that relief. There's not even a dispute that FSU has not been receiving the payment for which it is entitled to receive under the grant of rights agreement. The ACC has been distributing that revenue to all of its members, and there's no claim from FSU that has failed to receive revenues entitled to under the grant of rights agreement or any other agreement it may have with the ACC. I wanted to address briefly some of the comments that were made towards the end of FSU's presentation when FSU was talking about whether Florida is the best place for this case to proceed or whether it's the only place for this case and these claims to proceed. Your Honor, as you're well aware, those are factors relating to the issue of the stay. They're not issues relating to personal jurisdiction analysis. The court in North Carolina has already determined that it has jurisdiction, and that is the entitlement of that court to make a determination about whether or not it has its own jurisdiction. So we're not talking about issues that relate to a stay and what place is the more appropriate forum for this case to proceed. We're talking about whether or not this court can exercise personal jurisdiction over the ACC. We also were talking, the court was also discussing the application of Chapter 119 to the ESPN agreements and what law applies to that. And of course, as the court's well aware, both the grant of rights and the ACC Constitution are governed by North Carolina law. And those are, in the end, the core questions that are before this court. This court, and to bring that issue to a point, this court could dismiss this case. And the separate lawsuit that's been brought by the Attorney General relating to the application of Florida's public records law to the ESPN agreements, that case will still proceed. That issue is ancillary to the core issues of this case, which is what are the meaning of those two contractual provisions that are governed by North Carolina law. So in the end, specific jurisdiction requires an anchor to or a tie to a specific cause of action. And the relief that they're seeking here is about the construction of those two contractual principles. What they're kind of attempting to do is look at other things that aren't relating to those, the relief and the cause of action that they're proceeding against, and hoping this court will then say, well, because of all those other things, I'm going to exercise personal jurisdiction over the claims here. And that's not permitted by Florida law. That's not how Florida law works under either the long-arm statute or under the due process claim. So, Your Honor, I feel like we briefed all these issues to the court well. If you have questions, I'm happy to answer them, but I feel that kind of we've exhausted most of these issues before the court in our briefings.
Thank you. I appreciate it. And I don't have any further questions at this time.
Thank you.
So, we started less than an hour ago. Give me 5 or 10 minutes just to get my thoughts together. No, I'm not going to have time to make a concise memorandum of opinion. And yes, I am going to rule. Yes, it might be a little bit scattered, but that's what you get when you get a verbal ruling instead of waiting a month with my schedule for or more for a written ruling. So just give me a few minutes just to clear my head and I'll be back in with a ruling.
Yes!
Okay.
Yes! Yes! We're going to get a ruling. We're going to get a ruling. We're going to get a ruling. I believe on the motion to dismiss, I think possibly, maybe, I think it's happening. Ladies and gentlemen, Judge Cooper and Leon County going to be given a ruling 5 to 10 minutes when he gets his thoughts in order. Yes! We get it, PATC community. We get it. Oh my God! Oh my God! Okay, we're gonna quickly go back into the courtroom. We're gonna have a ruling, and then if the ruling does not go pear-shaped, hopefully we'll get some information on what is next. Some sort of next hearing on discovery. I don't know. Just give us something. That was a 5-hour root canal. Tracy FSU, hallelujah. Holy smokes. Tracy FSU, peace be with you. Thank you, Tracy FSU. Thank you for your generosity. Thank you for coming on here. Thank you for being patient with all of us. Holy smokes. We're about to get a ruling. I think it's going to be very good news for Florida State. I think it's going to be very good news for Florida State. Thank you so much, Ryan Willie, for your incredible generosity once again. 5 gifted memberships. The MGC Sooner, Florida Man, Dan Miter, Baby Wants Bling, and 2 King Slots. All 5 of you are now hereby knighted Cloak and Dagger. You can go to our YouTube channel and check out the member-only early Pete Cloak and Dagger episodes. Ryan Willie, the Evil Badger, thank you once again for your generosity, your incredible generosity. Wisconsin Badger, a proud Badger. Thank you. You are hereby knighted Cloak and Dagger once again. Thank you so much. The Architect, we made it. We absolutely made it. Yes, he did. Dale Simmons. Got to make sure I don't want to miss this. Don't want to miss this. We want the ruling. Again, it's not going to be pretty. It's not going to be precise. It's going to be a ruling. He's getting his thoughts. He's getting composure. 5 or 10 minutes. Cooper is coming back with the ruling. And I believe the ruling is going to be on the ACC's motion to dismiss. Now, I think we all can agree, we believe Judge Cooper is going to deny it. But the words and how he explains his denial is important. And then, what is the next step? Don't talk about mediation. Because it ain't gonna, if there is true negotiations going on, it ain't gonna be done in this court. No offense to Leon County. No offense to Judge Cooper. But my goodness, the ACC lawyers, it's gonna happen outside. It's gonna happen in some hotel room, some conference center, some building underground. It ain't going to happen. It's going to be a tight circle with every interested party being involved. It ain't happening in Leon County. I don't think so. Please don't talk about mediation anymore during this show. Let's get on with it. Ruling, and then what is next? What is next? What is next? First pitch in the baseball game, Brett Taylor, Florida State Seminoles. Got both on my computer running simultaneously. Hope he doesn't come back with a nothing burger. Have they talked about mediation? Oh. Mediation is a good word. It's a very, very good word. I hope they do it. I hope they're doing it now. I hope right now, somewhere in this country, right now, the ACC and Florida State and Clemson and whatever are all talking with each other. But no more time talking about it in the courts of Leon County. No more. Please. Please. He gave the ACC one more chance to mediate. They can mediate without Judge Cooper. Greg, the point I was making is I don't think the ACC can mediate, and I get it, Larry. Thank you for the phone call. I'm sorry about that, Larry GM. I apologize for that. I agree with you. I mean, they can, but it's really complicated. But I understand your point. There's a whole bunch of different interests within the ACC. It's going to be difficult. And it's going to take time. It's even going to take time to agree to mediate. I'm not going to completely rule out that it's not happening now or it's not going to happen in the future. Maybe it is. But it's a complicated business, Larry GM. You're absolutely right. There's not going to be any cheeseburger. Not going to be any extra cheese. Not going to be anything on my burger but good grilled onions and some other seasoning and possibly some bacon and possibly an egg or possibly grilled mushrooms or barbecue sauce. A whole bunch of things can make my burger delicious as you guys lay on that meat tasty, that the cheese that takes away the taste of the meat. One of you in the PATC community is going to wake up and go, my goodness, Greg has been correct. Hold on. I got something else to report. Hold on. And we have been saying this. Let me hold on a second here. Matt Baker, Tampa Bay Times. Of note, the ACC Council says there's no dispute. Now listen up, PATC community. Listen up. Listen up. Of note, the ACC Council says there's no dispute about Florida State getting the money it has been owed. There's been some message board speculation about whether the ACC would keep paying Florida State after the lawsuit. We have Peek Around the Corner. We have been telling you there is no reason why the ACC would not be paying Florida State. There has been some Florida State insiders that said Florida State ain't going to get paid. It's going to push Florida State to file notice of withdrawal and all that other stuff. None of that was true. There was no reason at all, according to the ACC bylaws, that Florida State was not going to get paid by the ACC. In fact, if Florida State filed a notice of withdrawal, then it gets complicated. Then maybe money can be kept from Florida State in due time. But not now. Not now. So again, another aspect of this drama, Florida State is going to continue to be paid as long as they are a member of the conference. And they are. They can battle this in the courts. They can force negotiations. They can do all of this without filing a notice of withdrawal. Keep that in mind. Keep that in mind. Okay, do we have anything going on? No, it is not. Nothing has happened. Nothing has happened. Florida man, let's celebrate with a good old cheeseburger. How about we celebrate with a good old hamburger? Hamburger! You are correct, Greg. Well, a blind pig can pick up an acorn once in a while. Somebody's going to have to tell me the advantage of filing an official notice of withdrawal. How does that make it advantageous for Florida State in the courts? I don't see it. If somebody can tell me, cheese. No, I like cheese. I got no problem with cheese. Just don't put it on my meat. Just do not put it on my meat. Hamburger and cheeseburger are the same thing. CFB is because you are a victim. CFB plus, you are a victim of the great cheesification, the great conspiracy in America. Gross. Get the cheddar off my sausage. Don't put it on my sausage. Don't put it in my sausage. The jalapeno sausage, that's fine. Greg, no cheese? Okay. I like to see one of you go into Christopher Mercado. You are absolutely brilliant. Absolutely brilliant. I've never had a cheeseburger in my life, and I don't plan on starting it now. Team Hamburger, Greg. Beautiful, Christopher. Beautiful. Go to New York City. Go into a deli. Go order a pastrami sandwich. A pastrami sandwich. Maybe put a little bit of mustard on that. Sometimes they give you... If you tell them, oh, can you put a layer of cheese on my pastrami sandwich? They would throw you out of that place like that. Why is it every great sandwich in America doesn't have cheese on it? Bacon, lettuce, and tomato sandwich. No cheese. Grilled cheese sandwich. No meat. Don't combine the cheese and the meat together. Talking about Judge Cooper wasting time, I'm wasting time. Again, there's nothing, Cooper is not back yet if you've just joined us. Judge Cooper, he's going to make a ruling when he gets back. 5 to 10 minute break. It's been about 10 minutes. He's going to let it marinate. He's coming back with a ruling, we believe, on the ACC's motion to dismiss. We believe he's going to deny it. And then what does he say? That's the important part of it. That is the important part of it. The Cuban sandwich, The Cuban sandwich doesn't need cheese. It don't need cheese. Doesn't need cheese at all. Ham and cheese is horrific. It's one of the worst things that has ever been brought onto this country. Pastrami is already a comprised brisket. Judge is back at the bench. Holy smokes. Holy smokes. We've got a ruling, ladies and gentlemen. You can yell at me later. You can yell at me later for our takes on cheese and meat. This is important. This is important. Come on, baby. Let's get a ruling. Let's get a ruling. If you just join us. Here we go. Back in session. Back in session. Hit the subscribe button. Smash the like button. Open up your notifications. College football's peek around the corner. Here we go.
No, it's not the one. Need a cracker. Hold on. I'll be right back.
No! 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 Where is he going? This is like a pick six against the Gophers. Iowa just scored to win the game the last 30 seconds. What? Ladies and gentlemen, if you've just arrived, college football's peek around the corner. It's been an excruciating day. It's like we all have gotten our tonsils pulled a second time around. Judge Cooper is finally going to make a ruling on jurisdiction, we believe. We're not even sure on that. We are sitting here. Judge Cooper has now left. Hopefully he'll come back. And after he's denied the motion to dismiss, then what is he going to say? Are we going to get some sort of management scheduled when it comes to discovery? What is the next shoe to drop? Because it's taken a long time for this shoe to drop. This is the third day. The third day covering April until now on the question of venue. The third day. Judge Cooper, make a ruling. Let's get on with it. Let's talk about something else in this court case. July 12th. July 12th, join us July 12th. We're going to do all we can to provide you a live stream in Pickens County, South Carolina. We don't know for sure, but we're going to try to put on a live show, Pickens County, July 12th, in front of Judge Gravely. So join us July 12th if we can pull that off. Thank you, Chris Hughes, for your super chat. Can't make this up. You're absolutely correct, Chris Hughes. Thank you for the super chat. Thank you for your generosity once again. Thank you for everybody's generosity, helping us keep the lights on, the great comments in the comments section. Thank you for all your help, Immaculate and others, navigating this day of in and out, live stream, judges coming and going. Thanks for everybody's help. Thank you for the couple phone calls that we have received. If you're new to the channel, please subscribe, smash the like button, have your notifications turned on because we could come on live later again today if there's breaking news. We go where the story goes in college football. And if I'm not getting you upset at least once a month, I'm not doing my job. Here is Judge Cooper.
I took a Tylenol. It wouldn't go down. All right. It's still here. Okay. So I want to thank the lawyers for bearing with me, for basically arguing this motion twice. About, 6 weeks ago, and today. Your briefing was excellent on both sides. I want to thank those back here in the courtroom who bore with us through this argument. I'm going to rule now. I will tell you that for me, the lawyers know this, it's not unusual for me to rule verbally in a case. Some judges will wait and write an order out. The number of cases I have just makes that much too lengthy for me to do. I'm not going to bore you with the number of cases, the lawyers know. But you're looking at my resource base right now. It's me. And I could do it, but then I would be not doing just service to many other people who have cases, and they need their cases heard too. So the result being, I think the lawyers will know where I'm headed and what I'm saying, but I don't have a pre-planned, thought-out ruling, because it's very common for me to have some perhaps notions of where I may go on a case to be completely changed by what I hear in court. As you all figured out, I don't think anybody expected me, I don't think FSU expected me to grant your motion to dismiss last time and replete it, but I think it's worked out to get a more detailed statement of FSU's position so all parties can understand it. And so I try my best to be as prepared as I humanly can. I have some outline of legal issues, but no pre-planned ruling. So I'm going to rule. It will generally follow a cohesive beginning through end, but I don't think the great novelists necessarily write a book from beginning to end without going back and editing some. And they're sitting down and writing on a table, on a legal pad, on a computer, whatever they choose to use. So I say this with, really, I'm honored to be able to hear these really good lawyers make arguments for their clients. My ruling doesn't indicate that I think one side, quote, wins, one side, quote, loses. We're not here about who wins and who loses. So just in general, I'll repeat again, on a motion to dismiss, I'm required to treat the factual allegations of the complaint as true and consider them in the light most favorable to the plaintiff. The test for a motion to dismiss is that a complaint should not be dismissed for failure to state a cause of action unless the movement can establish beyond any doubt that the complainant could prove no set of facts, whatever, in support of his or her claim. And that's, the case site is 869 Southern 2nd 30, Florida, 4th DCA 2004. Now, that's the general rule for motions to dismiss, but a motion on personal jurisdiction has a twist to it that's not exactly what I just read to you, and I recognize that. In Florida, we follow, you may have heard us mention the case Venetian Salami Company versus Parthenis. I don't know if I pronounced that, but for the court reporter, it's Partheneais, and it's 554 Southern 2nd, 499, Florida, 1989. That means it's a Florida Supreme Court case. And that's the case you hear from, to those of you who are non-lawyers or lawyers who don't work in this area, the Venetian Salami case is usually the first case you hear from a lawyer who practices in this area. And again, I don't have it directly in front of me, but I do have kind of an outline of that case. And so the way I look at it is Venetian has a two-part ruling. First hurdle, second hurdle. The first hurdle is the plaintiff in the complaint must allege sufficient facts to bring the case within the ambit of Florida Statute 48.1931 or any of the other sections of Chapter 48.193. That's what we call the long-arm statute. And there are other cases. Just a second. I'm also in a moment going to cite to you another case, and it's called Belz, B-E-L-Z, Investco Limited Partnership, Grupo, and two other names which I'm not going to try to pronounce, 721 Southern 2nd, 747, 3rd District Court of Appeal of Florida, 1998. So one's a Florida Supreme Court case, one's a Florida 3rd District Court of Appeal case, which is down south. We're in the 1st District, this is the 3rd District. However, unless the 3rd District case conflicts with what the 1st District says, I'm bound by the 3rd District case just like I would be by the 1st District case. So what's interesting is the Belz case points out a little bit more about what I call point one, or the first hurdle, how you meet that. The plaintiff bears the initial burden to plead sufficient facts to bring the action within, as Venetian said, the ambit of the long-arm statute. The Belz case says this may be done, and I think they're taking from Venetian language, so they're just amplifying what Venetian's already said. This may be done by alleging facts sufficient to show that the defendant's actions fit within one or more subsections of Florida's long-arm statute, and it may also be done by tracking the language of the long-arm statute without pleading supporting facts. So here the plaintiff has done both in their second amended complaint. It's alleged several different bases for its allegations of long-arm jurisdiction. I think the one we focused on the most is 48.193 1A1, which is operating, conducting, engaging in, or carrying on a business or business venture in this state, having an office or agency in this state. I think, and I so rule, that the plaintiffs have met the burden of the first element of the Venetian by its allegations in the complaint. Both they've just referenced that statute, and that's sufficient. And two, they've given, I'm going to say kindly, a fairly lengthy amended complaint setting forth facts outlining many aspects of their claim. So I think on both bases they've done that. I think I'm not discounting, and I think they have also founded on the other portions which they've argued in the memorandum, in the oral argument, and in the second amended complaint. However, I think the carrying out a business in the state is the strongest of the arguments. And instead of me going through all of those, I don't want to keep us here all afternoon. They even, this is assuming, and I have this highlighted on my statute, which means I read your complaint and I highlighted the allegations you made of 48.193. And so my statement I'm about to make is under the understanding that the plaintiff has made allegations regarding that specific section. That's why I have it highlighted here. So that includes 0.193A1, 1A1, 1A2, 1A6A, and 7. And they've alleged that in the complaint. They've also alleged facts in the complaint sufficient to support that. But that's not where it stops. The next thing, if plaintiff has met that burden, the defendant may contest the jurisdictional allegations by filing affidavits. And if the affidavits are such that there are sufficient non-contested facts to go forward, there's no need for a court. You notice I never refer to myself as the court. That's not my name. There's no need for a court. There's no need for me to hear testimony. And that's why if you were here this morning, you heard the lawyers have agreed there's no need to call witnesses unless I specifically ask for it. And I agreed with them. I've read the plaintiff's, I've read the defendant's affidavit. I've read the plaintiff's affidavits. I went through, and I won't repeat that, the affidavit of the affidavit of Mr. Lario, I believe. Here it is, which the defendant filed. And a couple of points to, I think, remember. A court, these are notes I typed out Sunday. A court may accept as true all of the plaintiff's factual allegations that the defendant's affidavit does not specifically take issue with. And I'm going to cite several cases, and you have to read the cases to draw this conclusion. One is Posner, P-O-S-N-E-R. I'm not going to give the full name, but it's 178 Fed 3rd, 1209 at page 1215, 11th Circuit, 1999. And that case noted that the defense affidavit, which admitted certain peripheral connections with the state, but denied in a conclusory way any other actions that would bring defendant into the ambit of Florida's long-arm statute, although presented in the form of factual declarations, are in substance legal conclusions that do not trigger a duty for the plaintiffs to respond with evidence of their own supporting jurisdiction. Let me put that in English for you. You can't trigger a factual dispute by just stating a conclusion or a legal conclusion as opposed to a fact. That's what the 11th Circuit, the federal court, appellate court that covers Florida, says. And then Gerber, the Gerber case, which is 917 Southern 2nd, 964 at 967, Florida 3rd DCA 2005, concluding defense affidavits failed to challenge allegations supporting specific jurisdiction. And the Way decision, W-A-Y-E, 638 Southern 2nd, 582 at 583, Florida 1st DCA 1994. Once plaintiff alleged defendant committed a tortious act in Florida, defendant wishing to contest jurisdiction must submit affidavits containing representations which, if true, would be legally sufficient to refute plaintiff's allegations. So, in reading those cases, I have come to the conclusion that in any personal jurisdiction case under Venetian salami, if the defense allegations do not contest or conflict with the plaintiff's allegations, we take legal conclusions out. But if they do not conflict with those, then I'm left with the original general proposition of considering motion to dismiss. I'm required to take allegations not challenged or conflicted with on their face value. Here, for this court, me, to have jurisdiction, it doesn't mean that I have to agree with every position plaintiff's made. Plaintiff only has to prevail on one basis for jurisdiction. So, in reading Mr. Terrio's affidavit, I went down before, I gave the paragraph numbers before, I won't repeat that. I believe his affidavit admits that FSU and Miami and ACC conduct and produce sports events originating from FSU and Miami home games, and they authorize that business relationship, authorized broadcast through ESPN and ACC network and other appropriate networks. I believe that's a business conducted in Florida by ACC along with FSU and University of Miami. Miami's in the ACC conference. So of importance here is Mr. Terrio explains in nicely drafted and succinct way that there's a thing called grant of rights, and what that means is that when FSU and Miami entered the conference, they signed an agreement with ACC to sign over the right to broadcast their games and to distribute their home games at least. It could be more, but for purposes of what we're doing today, I think it's enough to say home games. They signed those over to ACC for a certain period of time that's set forth in the grant of rights contract. In return for that, ACC receives revenue from ESPN, and with respect to bowl games, others, and for the broadcast of those games, and has significant control over the broadcast of those games, as we've discussed here, and also part of ACC's obligation is to pay FSU and Miami a certain portion of those funds that ACC's received from the grant of rights. I don't think I have in the record, unless it's in the record and I've just missed it, exactly what proportion that is. I've seen references to total amounts that have been paid, but not as to ratios or percentages of what's been paid. So I have concluded to talk a little bit in more detail about the business aspect of 48-193. I have concluded that ACC has sufficiently pled and proven, in its memorandum, the requirements of 48.193 1A1, operating or conducting a business venture in Florida, or having an office or agency in this state. The way I read that is if you operate a business in Florida, you don't have to have an office or an agency in this state to meet that rule if you engage in a business in Florida. So I find that the complaint sufficiently alleges and the affidavits do not sufficiently dispute that ACC is in the business of exercising FSU media rights for FSU home games. The same applies to Miami home games. And that this lawsuit is related in substantial part to how ACC values those media rights and how they exercise those media rights. Anytime one's doing a summary, it must of necessity be short and might not claim all of the side issues, but the side issues are there. So step 2 in the salami analysis is, let me get back to my notes here. If the allegations in the complaint sufficiently establish long-arm jurisdiction, I find that they have, then the burden shifts to the defendant, that's ACC, to contest the jurisdictional allegations in the complaint, which it has by affidavit, and I've discussed that, and I've indicated that the affidavit doesn't sufficiently contest affidavits to nullify the support in the complaint for establishing point 1 of Venetian salami coverage under the long-arm statute, comma, or to claim that the federal minimum contacts requirement is not met by the way of affidavit or other similar sworn proof, or as here today, it could simply be by argument based upon the facts of record, both in the Second Amendment complaint, the attachments to it, affidavits filed by the plaintiff, or the affidavit or materials filed by the defendant. Those all can be considered. I've considered all of them and read them all. If properly contested, I'm reading from the Belts case, the burden then returns to the plaintiff to refute the evidence submitted by the plaintiff, also by affidavit or similar sworn proof. And the Belts case is essentially just a different way to state what Venetian Salami said. So let me go back to some notes that I have here. All right, I have found that the complaint sufficiently alleges that the ACC operates a significant business in Florida regarding exercise of FSU's media rights, using those media rights as a source of programming for the ACC network and or licensing to ESPN to use for certain payments. I don't think it's any secret. I'm not sure this is in the record, so my ruling isn't based on this in any respect, but I believe the ACC network has some sort of official affiliation with ESPN, but I'm not sure that's in the record, and again, my ruling is not based on that determination. So then we go to the second prong of the test, and whether what legal scholars describe in different ways. Some call it a minimum contacts analysis, some call it the federal due process analysis. I think either applies, and I may use those terms interchangeably. I look to the Louis Vuitton, as Louis, Vuitton, Vuitton, case, 736 Fed 3rd, 1339 at 1355, 11th Circuit, 2013. In that case, gives what I call a three-part process to consider, or three elements to consider. The first is whether plaintiff's claims arise out of or relate to at least one of the defendant's contacts with the forum. The forum means Florida. Two, whether the non-resident defendant purposefully availed himself of the privilege of conducting activities within the forum state, within Florida. And three, whether the exercise of personal jurisdiction comports with traditional notice of fair play and substantive justice. So, I want to go back to set the way the U.S. Supreme Court instructs us to consider a due process analysis for jurisdiction, and that's, I believe, in Justice Gorsuch's opinion in Mallory, Mallory, 2 2023 WL, that stands for Westlaw, 4187749 US 2023. That's a US Supreme Court case. We've discussed that before, so I'm not going to go through the analysis. I recognize there are parts of the Mallory case that are factually different than this case, as I've indicated before. But I cite that case with this admonition from Justice Gorsuch. Unquestionably, too, International Shoe, that's a 1940s era U.S. Supreme Court case, saw this flexible standard as expanding, not contracting state court jurisdiction. As we later put the point, the immediate effect of International Shoe was to increase the ability of state courts to obtain personal jurisdiction over non-resident defendants. In this case, I cite this case for what I consider the increasingly expansive view of personal jurisdiction that Justice Gorsuch articulated in the Mallory decision. I think that adds to additional support for the position of the plaintiff in this case for establishing due process rights. That in and of itself doesn't do it, but it lends support to its case. Here, let me flip through. Okay, the arise out of or relate to, which is element number one of the Louis Vuitton case. It seems to me the issue here is whether this case and the claims in this case arise out of or relate to the business that ACC is conducting in Florida, which is the primary focus of that business is to market and exercise FSU and Miami media rights for home games. There's a marketing aspect of it. There's the Fanatics marketing company, that's part of it also. But the marketing aspect also is arising out of or relates to the ACC ability to control. I can't take phone calls now. I'm sorry. For FSU I should have had that turned off. Also, sorry about that, guys. I think the suit is related to FSU's valuation, to ACC's valuation of FSU's media rights and how they exercise those media rights. There are other various claims brought in the case, but these appear to be the focus of the case. So I think the first prong is met. On a broader basis, FSU and Miami both have signed over their media rights to the ACC, and assuming that the Miami contract is similar terms as FSU, they've signed over access and marketing access or media access of their home games, and also they turn over the at least partial control on those games to the ACC. Then we have number two, whether the defendant purposely availed himself or itself, in this case, of the privilege of conducting business activities in the state. Let me go back to the arise out of and relate to. It's called the relationship aspect of federal due process. Bristol Myers Squibb, I've cited this case before, 137 Supreme Court, 1773, U.S. Supreme Court, 2017. They say the relatedness prong of the personal jurisdiction analysis considers whether there is an affiliation between the forum, the defendant's contacts with the forum, and the underlying controversy. I discussed that earlier, so I won't repeat that. The number two is what I call the purposeful availment. And is whether there's an intent with ACC activities or business activities in Florida to invoke or benefit from the protection of Florida's laws. Here it seems to me that FSU and the ACC in Miami have contracted with the ACC network to provide, with regard to media rights, and with ESPN, these are multiple contracts, to provide content to ESPN as sold by ACC to ESPN, an ACC network consisting of FSU home games and Miami home games. So, and those games are in Florida. Those games are at least in part under ACC control, at least in part under its rules and procedures. So it seems that by operating a business in Florida, that necessarily means that one has subjected itself to the laws and the benefits of conducting a business in Florida. It may be the court system, it may be the legislature, it may be the executive, it may be the high or low or medium tax, depending upon your viewpoint. It may be whether there are intangible taxes in Florida, whether there aren't. It may have to do with the school systems, any number of factors controlled by the Florida court.
Okay. I'm not going to be able to listen to any more of that. The motion is going to be denied. People have already written. Matt Baker has already written on it. He's filed an article. One other thing here. The first hearing for ACC versus Clemson in North Carolina. The first hearing, ACC versus Clemson in North Carolina, is currently slated for July 2nd. So if we can do a live stream out of the North Carolina, we'll do that July 2nd. Clemson versus the ACC. That hearing is going to be on a summary judgment, is going to be July 12th. So keep July 2nd and July 12th. Keep that in, put that on your calendars. So today goes Florida State. The case is going to continue in Florida State, and hopefully some point when the judge stops talking, he's going to initiate what is going to be next. Is there going to be some sort of schedule in regards to discovery? What is going to happen next? I'm hoping for it, but we're not going to cover it live for right now. I got to get going. I've got a lot of things going on. And a lot of it has to do with college football. There is other stories to cover. So I am going to continue to work on keep your head on a swivel. We might be going on live later tonight. If not, definitely tomorrow. Keep your head on a swivel. We've been on the air for over 6 hours. So we're going to have to pull off. I'm going to have to get back to work. And we've got a whole bunch of other stuff going on. Ryan Thomas, thank you. Motion to put cheese on Greg's hamburger is denied. So let me know. Send me a post on X, on Twitter. Let me know what the judge says at the end of this. But the motion to dismiss has been denied. The judge may go on for another half hour. I don't know. But I don't have the time. We got to do something else. So appreciate you all coming on in. I appreciate everybody. This was a historic day. The case will continue here in Leon County, just like it's continuing in Mecklenburg County. The two important dates, July 2nd and July 12th. July 2nd in Mecklenburg County, Clemson versus ACC, and in Pickens County, ACC versus Clemson on July 12th. Keep your head on a swivel. Make sure you subscribe to our channel. Smash the like button and have those notifications turned on. We might have to come on live again later tonight. So keep an eye out. Open up those notifications. And we will continue on covering everything in college football. Thank you for the generous donations, the comments in the comments section, and the phone calls. Until next time, from all of us at College Football's Peek Around the Corner, to all of you, please, 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 you all take great care of each other. Thank you so very much.